Lord, may I have your lordship's kind leave to pray for an urgent leave of your lordship to move this matter on Thursday, my lord. This is a second SLST matter, my lord.
On Thursday?
Thursday, my lord, because Tuesday and Wednesday your lordship has fixed several SSC matters.
Yes.
That is why, my lord, I am praying to move on.
What is the urgency?
Urgency is, my lord, these petitioners have chosen education as a subject for 11-12. My lord, the rule says whoever filled up the application form and sat in the written examination should be called for verification. The commission, what the commission did, my lord, at the time of verification, they applied 1:1.6. Dear my lord, tainted candidates everywhere called. Subsequently, they were rejected. Many of them rejected. In effect, my lord, if those were screened at the very beginning, which the rule says, I would have been called for verification and interview, my lord.
But then this issue is also pending, isn't it?
No.
Whether the ratio will be applied at the time of interview stage or at...
No, that is, my lord, the 10 marks. That issue is pending.
All right, this is not pending.
No, this is not.
Lord, in another matter.
Affirm and then give.
My lord.
This is an affirm petition, my lord. Extreme urgent. Second SLST, my lord. My candidature has been rejected primarily on the ground I made a mistake in the form fill up. I'm a female candidate. It was filled up as male candidate.
Wow,
By
that's a lovely mistake.
Kindly
responsibility.
visualize, my lord. There are ample number of judgment. If I have passed out the selection process above the cutoff marks, and my lord, if such a mistake is not trivial, which would have any problem in the selection process, my lord, there are ample number of judgments, my lord. These are condoned, my lord. I will show, my lord. Any day, my lord, your lordship may kindly give a very small mistake, my lord. I'll place it, my lord. It was done by the computer center, my lord. They have done the mistake.
Well,
My lord, any day.
when? Any day means Tuesday, Wednesday,
Thursday, your lordship.
Thursday.
But may I be permitted?
Affirm.
But may I be permitted to mention the application for restoration with section?
No inclusions.
But next,
No inclusions.
Correction give. Correction.
Contempt application. On prosecution give. It will appear as to be mentioned, then order will be passed.
Contempt application.
No inclusions.
Lordship, may I permit to mention an urgent motion for upgradation, Lordship? The
No
urgency
upgradation.
For correction, madam.
Correction give.
Lordship, may I be permitted to mention one matter, craving leave to drawn up and completion of the order passed in a
All
contempt.
right. Original side.
my inclusion the next month list.
Isn't it original side? Yes, give. Hand over.
My lord, inclusion is the next month list. February.
I have taken up more than 200 slips.
Madam, may I be permitted to mention item number 73 and 75? Madam, both are second SLST. Madam, the PH candidate. Madam, the
It is there in the list. Why are you mentioning?
madam, if you lot upgrade this,
No upgradation.
madam, kindly, madam, the counseling is going on.
I understand. Next week, let us see. We'll take up the SLST
My lord, two
matters.
second SLST matter I have filed. My lord, appearing date is next coming Tuesday. My lord, may I after listing them? I will wait.
No, don't mention anything.
Lord, may I be permitted to mention one contempt application?
For what?
Lord, for my order was passed on
No. For why are you
contempt
mentioning?
contempt application
Why
for
are you
inclusion.
No inclusions. Yes, sir.
Mentioning this matter for item number 117, today's list for non-prosecution.
Today's list item number 117. That means it must be a new matter. You file it and you immediately non-proceed.
There are
not
some
want to.
discrepancies in the In the matter, please grant us leave to
Give.
file afresh.
117.
117. Please grant us
117.
leave to file afresh, ma'am.
The non-prosecution to be mentioned. All right, call the list, please.
Ma'am, kindly leave is given for filing afresh.
Let it appear. No order has been passed today. It will appear in the list. Yes. এগুলো কি সব application?
My lord, can I intervene once? I have the instruction from the client as well.
Who has instructed you? Who has instructed you?
Ma'am, my senior,
Who is your senior?
ma'am, Roswanta Kaur.
Come this side. Come this side.
The
Yes.
matter has been, lady, the matter has been filed without the annexing few annexed, my lady. We want to withdraw the writ petition with the liberty to file afresh. The matter has been listed as item number
117.
117, my lady.
It will appear in the list under the heading to be mentioned.
Great, my lady.
Correction, কি correction আছে?
আমি তো বোর্ডের হয়ে সেকেন্ডারি বোর্ড পিটিশনের হয় দ্যাট আই এম নট অ্যাওয়্যার অফ
হ্যাঁ? হ্যাঁ। জ্ঞানই তো নেই।
কারেকশন তো লেখা আছে list এ। না না এক দেখেছি এক এক ওটা তো অরিজিনাল সাইড ছিল এটা অ্যাপেলিক সাইড হয়নি তো
Oh, please come. Leave is granted to the advocate on record of the petitioner to correct the presentation form, comma, and the front sheet of the writ petition.
ও welcome. You know
I'm preparing on behalf of the state.
But who I appear for the commission?
It was mentioned for non-prosecution of one of the clans. Where is the petitioner, the clan applicant?
I for the petitioner, but it was not mentioned by us.
No, you are for the writ petitioner,
Yes, your lordship.
but then possibly can one was mentioned.
And one is at the instance of Shami Mamed
Yes.
and can
Order
two
এখানে আছে। No, I do not want can 2. Possibly can 1 was mentioned for non-prosecution. The applicant is not here.
Is Mr. Shamir Haldar, the applicant, advocate on record for applicant in
Shamir
can
Halman is the advocate on record for can one.
Mr. Shamir Haldar mentioned that some of his client wants to not prosecute it and he
Yes.
filed a fresh can.
Can is it? Is it
Can
can
one,
2?
can one.
1 is it? I remember can 1.
no
The Singh is saying can 2.
my lord Somir Haldar's application is can 2
Can two, my lord. Mr. Haldar had a talk with me regarding.
So he had a
I
talk
was
with
wrong,
you.
I was wrong, it is can two.
2
Two.
can 2
Mentioned for can. I remember can 1 was mentioned.
এই তো আমার কাছে আছে
We do not want to proceed in case number can 1 in connection with such and such. Suman Chaudhuri, such and such. Can 1 who is on record? Gulshan Wara Parveen. Yes, she mentioned.
can 1
Please come.
advocate on record গুলশন আর পারবেন না
ওটা allow হয়ে গেছে। 2025 has been mentioned. Petition আছে। Mentioned for non-prosecution. Stuff. the communication made by the applicants to the advocate on record. He written with the records, stop. And one stands dismissed as not pressed.
The entire can.
Can one.
Entire.
Entire. Everybody has signed.
Oh.
And there is a communication to the on record. They do not want to proceed.
And one.
Can one ta?
One.
They are added as parties. Addition of parties.
Can one is also
That
mentioned.
was allowed. এবার ওরা বলছে আমি
The minority thing.
addition of
The Haldar is here in court.
can one.
No, can two.
Wait, can one was mentioned. There is a communicating letter not to proceed. Can one, I am passing order. তাহলে এগুলোকে দেখতে হবে। সুমন চৌধুরী কোথায় আছে? এই যে প্রীতি পাল, বিভাস, জগদীশ, নওশাদ, তুষার পরপরই আছে। তাহলে from 6, 7, 8, 9 তুষার, জগদীশ, নওশাদ, বিভাস। হ্যাঁ 6 to 11 stands expunged from the cause title of the writ petition. তাহলে আর উপরের লাইনটা দরকার নেই। ঠিক আছে। Yes to.
In last occasion, I also mentioned that in can two application, they are amended as a respondent from 12 to 16. They are also want to expand their name. Mr. Dhar was present there, and their name.
Where is the written communication from your client? Give.
Yes, করবে না, can two.
Can two.
Maybe they have been called for interview or something of that sort.
No. This is the pipe communication that they are individually communicated me by issuing the letter that they are.
You are the on record.
I am the on record.
12
to 16.
12 to 16. ওদের নামও expunge. All communications written with the records. এগুলো সব রেকর্ডে থাকবে।
কপি আছে তো?
এইটাকেও কিন্তু সামনের দিকে করে দেবেন। এটা মেনশনিং এ স্লিপ, এইটাকেও হ্যাঁ এগুলো সব থাকবে। হ্যাঁ, they do not want to proceed. Yes. তারপর এই communications written with the records. আনিয়ে নিন যদি না এসে থাকে।
I am deeply obliged.
হ্যাঁ, এটা যখন রিটার্নেবল আছে তখন আসবে। এটাতে শুধু মেনশন হয়েছিল ফর expunging their names.
Email I am for the petitioner method. Petitioner pair for transfer method on ground application to quota. Stage 37 method. First March 2022, my lord. Application
Pending before the HOI and it was returned back on the ground. There was shortage of staff.
Thereafter, petitioner again applied.
Yes.
First March 2022, my lord.
1st March 2022.
Pending before the HOI.
All right. Transfer application আমাদের usual order আছে. It is pending before the school authority. Yes, sir. Transfer before the school. একটু দেখে নেবেন. Yes, disposed.
The petitioner, transfer on spouse medical ground pending.
For the state.
pending before the commission. Your lordship kindly turn page number 18. That's serial number 1, 16th of June 2022, DI to to SSC, forward WBSSC for taking necessary. Page 18, 180.
Pending before the commission.
Spouse medical.
All right, disposed.
Great.
For the commission.
Right. I'm for the state. Appearances, please.
I am appearing on behalf of the state.
My lord, which is pending before the School Service Commission.
Page-
This is, your lordship will find it page number 2020. My lord, it is a transfer application on medical ground.
Whose medical ground?
My lord, of the petitioner.
Teacher.
Self-medical ground.
Teachers,
Yes.
self-medical ground.
Pursuant to your lordship's earlier direction is served upon the school and everyone again.
All right, it's pending before the school. All right, disposed.
The affidavit of service, new affidavit.
Yes.
is taken on.
Right. Service is taken already.
But my application for transfer, my lord. But this is made on medical ground. My lord, here.
Self-medical?
No, my lord. Medical ground of the spouse.
Spouse medical ground.
Now, my lord, it is pending before the School Service Commission. One thing, my lord, I must apprise to your lordship that though it was a special ground, in this meantime, the spouse of 40 years, my lord, he passed away. On whose ground, my lord, I made this application, my husband.
So nothing remains. Now you are not required to, you do not want your transfer.
My lord, now situation, my lord, is this. My lord, I am again, my lord, covered by that, my lord, the another special ground of my problem for the, my lord, reaching to the school for the death of
Distance ground.
for the death of the husband, my lord, a special ground.
Special ground.
Now, my lord, it is already reached to the School Service Commission. If they could just take care of this, my lord, as early as it is possible. If I take your lordship, my lord, to page number.
My lord, so far my understanding was applied on the spouse medical ground.
That is no longer there.
No long, but yes. So
So whether you are required to make a fresh application, that is to be seen. Where is your application? Please show me.
My lord, kindly see my application. Your lordship will see. My lord, my lord, page number 20, my lord.
Yes, 20.
Oh, sorry, my lord. Page number 21. The next page.
21.
Yes, my lord. But your lordship will see that the application was 3. is the
Commission?
Yes, it reached up to the School Service Commission, my lord, on
Will maybe transferred.
31st on August of 2021.
Right.
So, my lord, still there.
When did the, no, but when did the patient pass away?
My lord, he passed, my lord, in 2025.
Right. So you have to make fresh application.
That will, my lord, again, my lord, will, my lord, put me again in this duress. Lordship will kindly appreciate. that
Your
I
application
follow your
for
lordship's point.
transfer was for the your spouse ground. Spouse has passed away. What remains in your application?
My lord, in that application, my lord, it is a special ground application, but fact remains, what your lordship is saying is absolutely right. But my lord, the fact remains that I'm still suffering for this, and I have once again the special ground, but I'll have to once again, my lord, undergo the entire from here to up there. If they,
It's to be.
if
And moreover, it is 21, 20. No, please come.
but,
Ashun, the petitioner sought transfer on special ground.
yes,
In the application, did you not mention that your husband was unwell or something? You did. Then
medical ground application. I give the death certificate of my husband. If it could be considered at that particular time, however, it is what.
Special ground, a special medical ground of her spouse. Stop. The application reached the West Bengal Central School Service Commission on 31st August 2021. Stop. Thereafter, the same did not proceed further. Stop. The husband of the petitioner breathed his last on 11th June 2025. Stop. The petitioner still presses her application seeking transfer. Stop. The court is of the opinion that the petitioner that it will be open for the petitioner to file fresh application seeking transfer, disclosing the ground for the same.
Grateful, Madam.
Stop. The application may be made offline.
My lord, grateful.
Stop. The head of the institution shall consider the said application in accordance with law and take necessary steps at the earliest, but positively within a period of 8 weeks from the date of filing the application. Stop. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the school. The death certificate of the husband of the petitioner handed over in court today be retained with the records. Writ petition stands disposed of.
Grateful, Madam. Great. Yes.
Civil, my lord, I am appearing for the petitioner, my lord. Transfer, my lord. On medical ground, my lord, of the wife of the petitioner, my lord. Application made, my lord, in the year.
Where is it pending?
My lord, at test 23, my lord. Transfer application online, my lord. And my lord, certificate of CMI, my lord. BMI, my lord, kindly come to.
Where is it pending now?
Due to single teacher, my lord, kindly come to page 28, my lord. SFP 4, my lord.
Yes, to civil, avoid single teacher.
In the school, my lord.
All right.
And my lord, BMH has also, my lord, certified that, my lord, this record, my lord, she is suffering. 26. Kindly come to page 26, my lord. SFP 3.
The petitioner seeks transfer on spouse medical ground. Single teacher transfer একটা order আছে সেটা হবে petitioner লিখে দিচ্ছি সেলফ মেডিকেল কি স্পাউস মেডিকেল কি ডিসটেন্স কি কিছু সেটা লিখে দিচ্ছি আর যেটা অর্ডার হবে সিঙ্গেল টিচার বললেই গৌরব দিয়ে দিতে পারবে আজকে বৈশালী আসেনি প্রদীপও বলতে পারবে
চাকরি ওখানে 3 নম্বর আছে আর একটার সময় ম্যাটার ফিক্সড হয়েছে একটার সময় স্মিতা দাস
I am appearing on behalf of
I am appearing respondent number 7 and 8 appearing online.
I beg to appear under the school authority.
Respondent number 7 and 8.
Hand over the slip, please.
My lord, on the ground of distance, and my lord, on the and his application for transfer, my lord, is pending before the school. And if your lordship kindly takes sees, my lord, page number 24. And he is a single teacher, basically a single post, but his application is pending.
But then a single teacher is not mentioned somewhere in 24. It's just pending. Let them take a decision. School.
As your lordship, please, my lord, the usual order that is passed.
Yes, school.
Grateful. The affidavit, subsequent affidavit of service.
Give.
I'm grateful.
I am deeply obliged, madam.
Great. My pleasure, your lordship. But this is my application for transfer, my lord. Here the headmistress, my lord, she herself, my lord, makes the application for transfer on her own illness. So, my lord, what happened? She made this application, but the school managing committee did not consider. So she came before this one. In this meantime, my lord, on 25th of July, sorry, 25th of November, she has been granted with the NOC from the school. In this meantime. So, my lord, even then, my lord, the application is not yet forwarded to the district inspector. My lord, senior is appealing for this district inspector.
The school has not forwarded to the district
Has not, only granted the NOC.
All right, please come.
Only granted the NOC.
The petitioner's application seeking transfer was considered by the school and no objection certificate issued. Stop. The school has, however, not yet forwarded the application to the district inspector of schools for consideration. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the head of the institution to forward the petitioner's application seeking transfer to the district inspector of
Is the head
schools.
of the institution, the president.
I said the president, the head of the institution, I mean, president of the school managing committee.
Fine.
To the district inspector of schools at the earliest, but positively within a period of 6 weeks from the date of communication of this order. Stop. The district inspector of schools shall thereafter take necessary steps to consider the matter in accordance with law at the earliest. Disposed.
This is a medical ground application.
Great, Pramod. I am applying for the commission.
Petitioner seeks transfer on self-medical ground.
My lord, the subsequent affidavit of service.
Please give.
I'm led by Dr. Patra, my lord.
Yes.
My lord, it's my application, my lord. This is my application for transfer. My lord, now this petition before your lordship is a single teacher. Well, if I take your lordship to page number 24. I'm sorry.
It's pending before the school.
Yes.
My lord, page number 24, if I request your lordship to see my lord, serial number 5 once.
Yes.
Serial number 5, your lordship will see it was
Single
previously
teacher.
rejected as single teacher. However, the last application your lordship will see at page, serial number 2. So, my lord, that was rejected, but for the expiry of the MCU validity, I'm helpless. So, my lord, I request your lordship, my lord, kindly, my lord,
The managing committee is still not there. In 22, it was
my lord,
rejected.
now I am instructed, my lord, it is there.
It is there.
But
So it's
lordship,
pending before the school. Ground?
my lord, my lord, I'm sorry, my lord, the distance ground.
Distance ground.
My lord, the distance is of, my lord,
Pending before the school.
no, my lord, I'm so sorry, my lord. I'm so sorry, my lord. This is the ground of, my lord, medical ground of the spouse. So it is a
Please
medical application.
make
Yes,
any
yes, yes.
submission.
I've already averred also. My lord, page number 9, paragraph number 9.
Self-medical.
Ground of the spouse.
Spouse medical
Wife's
ground.
medical ground.
Pending before the school. Yes.
My lord, the
Disposed.
last affidavit of service.
Please give.
That I am for the status only.
My lord, here, my lord, I have challenged this rejection. If your lordship sees page number 30, my lord, on the ground of my husband's cancer. My lord, page number 30, if your lordship kindly sees once.
Yes.
My lord, page number 30, if your lordship will see, serial number 4 is my application. Kindly sees serial number 3. Here the school forwards it to the DI, but my lord writes what? Says that both husband and wife are the assistant teachers of the same school. 6 vacancies are there. Husband operated and such and such. And but visually now fit. He says that he is visually now fit. Authority requested to take steps for interest of students. So he still forwards to the district inspector. Now, my district inspector naturally rejects my application by saying that strong anti-remarks by the HOI. So, my respectful submission before your lordship, it is beyond the jurisdiction of the head of the institution also, though, my lord, he did not reject my application. To comment
When
upon.
the DI mentions, when the head of the institution clearly mentions that they, husband, wife, both are working,
In the same school.
visually fit.
Visually
fit.
Can he comment on this? Malad, I'm asking this question to myself. But however, Malad, he very
Let
nicely.
medical examination
Yes,
be
yes.
conducted.
That is only what I pray.
Ashwin,
By the district
the
inspector.
petitioner seeks transfer on spouse medical ground. But see, your husband and you are in the same school.
Same school, madam.
Then the husband
That is the confusion. That is the confusion all.
the husband is also required to be transferred.
Uh,
Who is the petitioner here, husband or the wife?
no, wife, madam.
Wife.
Wife.
So the wife will go somewhere else.
No, my lord. What happens here, my lord? He also, my lord, made an application for transfer in this meantime. So, my lord, that is perhaps, my lord, dying with the school services. That is what I am instructed. So, my lord, he's anyways going
Both
to
are
get
applying for transfer.
Both applied for transfer.
So, my lord, but that is already reached because he has got cancer, my lord.
If two teachers from one school goes, then the school will face problem.
My lord, that is there, my lord. But the rule also, my lord, provides the mechanism how to, my lord, deal.
No, that's all right. কি বললাম? Spouse medical ground who is suffering from cancer. Stop. The head of the institution forwarded her application to the district inspector of schools with the remark that the petitioner is a single subject teacher. Stop. The petitioner and her husband both are teachers in the school. Stop. The husband of the petitioner was operated in 2017, but visually appears to be fit currently. Stop. On perusal of the remarks made by the head of the institution, the DI returned the application of the petitioner to the head of the institution by mentioning that there is strong anti-remarks of the head of the institution. Stop. Paragraph submission of the petitioner is that the head of the institution does not have any jurisdiction to comment upon the health of the patient. Stop. The same is the jurisdiction of the medical expert.
Madam.
Stop. Next. Upon hearing the petitioner and on perusal of the documents placed before this court, it appears that the head of the institution is aware that the husband of the petitioner has a medical issue. Stop. He was operated. Stop. Whether the spouse of the petitioner appears to be visually fit or not is not a consideration to be made by the head of the institution. Stop. The head of the institution ought to have forwarded the patient for medical checkup in accordance with the transfer rules. Stop. By merely looking at a patient, the head of the institution may not be able to identify the physical problem that the patient may be facing. Stop. Paragraph. In view of the above, the head of the institution is directed to process the application of the petitioner in accordance with law and proceed for medical examination of the spouse of the petitioner. Stop. Steps shall be taken by the head of the institution at the earliest, but positively within a period of 8 weeks from the date of communication of this order. If the medical expert, if the block medical officer of health opines in first it is the block, then it goes to CMH.
Then it goes to the CMH.
Block medical officer of health opines in favor of the patient, then the head of the institution shall forward the application to the district inspector of schools for taking consequential steps in the matter. Disposed.
Great. The last affidavit.
Please give.
Well, my lord, I am for the
Okay.
commission.
But this is my application, my lord, for transfer, and it is stuck to the school.
Page.
My lord, your lordship will find at page number, my lord, 23. No, sorry, my lord, 23. My lord, 23, serial number 2, your lordship will see it forwards to the district inspector. I'm sorry. My lord, she makes the application, my lord, serial number 3, and it is forwarded to the district inspector. But the district inspector, my lord, returns it to the school by saying that follow the 3rd January notification, which is completely, my lord, an illegal action of the district inspector. And now it is stuck to the school again, because the district inspector has to, my lord, exercise the 3rd January rule.
Single teacher.
Single teacher.
The petitioner's application seeking transfer was returned by the head of the institution. Now, returned by the district inspector of schools to the head of the institution with the observation to follow the order of the Commissioner of School Education, West Bengal, dated 3rd January 2022, pertaining to transfer of single teachers. Stop. As per the aforesaid government order, the district inspector of schools is required to take steps for making alternate arrangement for teaching the students in the event the petitioner's application for transfer is allowed. Stop. It was absolutely improper for the district inspector of schools to return the application of the petitioner to the head of the institution. Stop. Next. Whether a single teacher of a school can be transferred or not has been decided by the court in the matter of Rupak Dhua.
Subject.
Yes, sir.
DI has already taken steps.
Yes.
Surrounding a school smilers. He has asked for the stop the measure.
Nobody came.
Nobody came.
Nobody will come.
Certainly, valid.
Why will somebody take extra responsibility? Nobody does it.
So that part, kindly record, my lord. DI has already taken steps, my lord.
He has failed. No use. আরেকটা লাইন এই ওয়েদার থেকে যেটা প্যারাগ্রাফটা বললাম তার আগে স্টেটের একটা বক্তব্য হবে Learned advocate representing the state respondents submits upon instruction that the district inspector of schools tried to make alternate arrangement, but none of the teachers of the nearby schools agreed to teach the students. ঠিক আছে এবারে ওয়েদার রূপক ধুয়া এবারে সিঙ্গেল টিচারের যে অর্ডারটা আছে ওখানে রূপক ধুয়ার প্যারাগ্রাফটা আছে সেইটা নিয়ে ওখানে disposed.
Great for me. Great. The affidavit of service.
Yes, please.
Okay.
Transfer application pending at the School Service Commission.
Page.
Page may be 29. I can give you an order.
You know.
All right.
এটা আমাদের vision। এটা আমাদের property। এখানে রাখলে কি যেতে বললো?
Very well. Dispose it off and reject the prayer. It's all right. এটা হচ্ছে usual order in case of commissioner কাছে যেখানে
Milord, 14 also, Milord, the 14 transfer application is 28. Milord, the just as like as item number 12, just now Mr. Rai Milord submitted. DI has Milord returned the applications on the same grounds as per the notification dated 3rd January. Page 28. Subject teachers making local arrangement. Although Milord, I have stated another teachers in secondary section. There is a judgment, Milord, the teachers available in secondary section. I am higher secondary section. So no alternative arrangement is required. Other than Milord, the 3rd January notifications, Milord, the concept of single teachers in terms of the judgment of group of those.
item number 12.
Just now.
Same order হবে তাহলে item 12.
Just now only submission,
Yes.
Milord, Mr. Chakrabarty, Milord,
Submission.
DI has taken step.
আচ্ছা ওই স্টেটের বক্তব্যটা হবে না। Item number 14 for the state recorder appearance.
তো সময় নেবে বলছে কি এর জন্য কি অন্য কোটে
হয়ে গেছে disposed.
বলছে সিঙ্গেল
Proceed.
সিঙ্গেল টিচার স্টেট
Single teacher.
তাই তো রে
Where is the
দেখতে তো কি আছে
roll strength very high, teacher strength not sufficient, will be properly, especially for mathematics unable to proceed. Paragraph 19. Reading
Page 44. Is pending before the school.
yes. Acha, please come. The petitioner's application seeking transfer made by the petitioner was is pending consideration before the head of the institution. Stop. Initially, the same was not allowed by the head of the institution on the ground that the roll strength of the school is very high, but the teacher's strength is not sufficient. Stop. But thereafter, the petitioner again applied for transfer, and the same is pending consideration before the head of the institution from 23rd March 2022. ঠিক আছে এবার স্কুলের কাছে পেন্ডিং আছে
On the ground of distance.
distance ground. Very well, disposed.
Happy New Year, my lord.
Happy New Year.
My lord, item number 16, I'm for the petitioner. Petitioner is a group D clerk seeking transfer on spouse medical ground pending before the commission. Your lordship kindly turn page number 22
Nothing is legible.
Yes,
It is just blank.
DI to SSC. DI to SSC.
Can you read page 22? I cannot.
From the copy of the petitioner, it is not readable.
Legible. That means, see, the copy that you have given to the court,
At that time, my lord,
it is absolutely legible. Nothing can be seen from here.
7th of July 2022, DI forwarded the application to the West Bengal Central School Service Commission.
It is pending before the commission.
If necessary, medical exam.
Is it the medical ground?
Spouse medical.
Spouse medical ground. Medical examination একটা লাইন লিখে দিন, সেটাও আছে আমাদের অর্ডারে। You have a copy?
No, my lord, I have, but your lordship's copy is there, my lord. They are common order, my lord. If required,
I know.
yes.
Commissioner pending. Spouse medical ground, তাহলে হবে check up of spouse.
Clerk, my lord, pending before the commission.
ও আগেরটা ক্লার্ক হবে কিন্তু টিচার নয়।
Group D.
This is clerk.
Clerk, my lord, distance ground application pending before the commission. Page 20. 27th March 2020, is forward to the DI to the commission.
Cannot read, sorry. You say it is commission, I take it is commission. All right. Next. Anybody was there for the commission?
My lord.
I am for board law.
Disposed.
Right, it is distance ground.
Met with the shallow. Application for transfer, my lord, is made out distance regular ground. It is, my lord, pending before the school. If your lordship kindly sees page number 28. Serial number 1 and 2.
Legible.
Adequate reason supporting documents as per BMOH observation.
দেখি তোর এটা legible নয় দেখি 28 টা বার করতে
Serial number 2.
Serial number 2, yes, it was returned from the head of the institution to the applicant.
Yes, that was the
28 টা বার
last
করুন,
part
আমি
one
commission
application.
হয়ে
Then, my lord, kindly see page number 1. Serial number
28 page.
5th of August 22, from the applicant, it was again
The
to the head of the institution, and it is pending.
and is pending.
Right, but the previous reason is inadequate reason supporting documents as per BMOH.
Proper medical certificate.
No, it is previous one.
Now it is distance
Distance
ground.
And, my lord, also a ground that I mentioned in my application that I had a strained relationship with the husband and there is a matrimonial
That
suit
is
is
a
pending.
special ground.
But it is only a matrimonial suit, no divorce is done.
All right. Head of the institution pending, ground is distance.
My lord, in the urgent, my lord, I'm appealing for respondent number 9. My lord, if the teacher, my lord, is there is no student, there is no teacher to teach the subject of geography, my lord, in our school.
So, my lord, see a single
Let it be
teacher.
considered.
There is a single teacher, there is no teacher as such to teach.
You intimate the petitioner,
Yes, my lord.
assuming that he is a single teacher, but the statute provides him a right for transfer.
Yes, my lord.
So whatever is required to be done, please do it. All right.
Or kindly, my lord, because the submission that they have been, my lord, withholding my application because of the reason I'm a single teacher.
But
for the
even then, if a formal order doesn't come, you cannot move ahead.
does, my lord, does.
Writing it means it will be the same ground that will be taken. You never know, some other ground may come this time.
As your lordship, please. My lord, the affidavit of sale. Great.
Distance ground.
The affidavit of sale.
Great. I'm for secondary board, your lordship.
Conduct of examinations, private examinations inside the school premises, Lordship, in complete disregard and violation of the government notification issued by school education department, Lordship.
Where is the notification?
Lordship,
শুধু মানে ওরা ক্লাস করতে পারছে না
না না না ই দেখো
served up on page 14, Lordship, of the supplementary affidavit, Lordship.
Who is appearing for the school?
My lord, I am appearing, my lord.
All right. Did you file your wakalatnama?
No, my lord.
Why?
Today, my lord, yesterday, my lord, I received, my lord. And today, my lord, I will get it, my lord.
This is a writ petition of 23.
No, my lord, yes, my lord, till date, my lord, I was not. Yesterday, my lord, I have received the copy, my lord. I was following, my lord, from the
সরকারি
cost.
দিয়ে আছে
Did you get the supplementary?
এডুকেশন
Yes, my lord. Yes, sir.
পরীক্ষাই হয়তো বিয়ে বাড়ি না আজকাল
Yes.
হসপিটালে দিয়ে আছে
Of the supplementary?
ছবিগুলো দেখো
Yes.
আমি দেখেছি picture গুলো
ও পিকচার কি দিচ্ছে
এই দেখুন না
Very, Lordship, it has been
মিটিং
clearly
মিটিং
stated, Lord.
পরীক্ষার এর ভেতরে কোথাও সেটা লেখেনি
May I read out, Lordship?
ও ভেতরে
No, I can read it.
কস্ট এক্সামিনেশনের কথা লিখছে
We use for purposes of
কি হবে লেখা
একটু কষ্টের পরীক্ষা লিখতে
দেখি ছেলেটা ছেড়ে দিই
না না এবার কি
কনসিডারেশন
না না
ছেড়ে দেন
এবার হয়নি আর এইটা এটা কিসের ছবি কোন ছাত্রের ছবি কোনো প্রমাণ আছে কিন্তু বাচ্চারা বসে আছে
লোকও আছে
হ্যাঁ তো লোক থাকবে না এই বড় স্টুডেন্টরা ছোট স্টুডেন্টরা
Who is the petitioner?
And the teacher is the approved school teacher, Lordship, of that particular school. Is an approved teacher having 20 years of service in that school, Lordship.
No, no, my lord, I dispute that, my lord.
Wait.
20 years of service, 2006. Initially, she was in a different school. After that, she joined the school after giving exam. And other
Isn't there a school managing committee over there?
managing committee there, Lordship.
They are not taking any steps?
No step. I made representation, Lordship. Page 11 of my writ petition, Lordship. Constant, Lordship. Constantly, they are conducting private examinations, Lordship. Constant exam twice in a year, Lordship. This year also from December, in the month of December, Lordship, that took place. Apart from other private examinations, Lordship. Hampering, Lordship, education of the students, Lordship.
And the examinations are held when?
In first exams, twice in a year, Lordship. One in June and one in December. Lordship.
On weekdays, on holidays?
In the school hours, Lordship. In weekdays. That is
Weekdays within the school hours?
Lordship, being a teacher, I am interested with the job of invigilation also, Lordship. This is hampering the school education department. 11, Lordship.
And there must be other teachers in the school also. Nobody is concerned. Why are you so concerned?
They have, Lordship, given their consent, Lordship. I am coming to that, Lordship.
It is not a matter of consent. Did anybody object to this before the higher authority?
No objection, Lordship.
Why?
I made representation throughout the Lordship, to the board, Lordship, to the school DI, Lordship, to the school education department. Nobody is taking steps, Lordship, because they must be in a position, Lordship. Let them reply, sir. Lordship, why are not taking steps?
This writ petition was filed in the year 2023.
Lordship.
Then why was it not proceeded with?
Lordship, it's a change brief, Lordship. I received few days back, Lordship.
And suddenly the urgency cropped up and everything happened.
Lordship, some Lordship, on some occasions matters were taken up, Lordship. It is not the matters were not taken up, Lordship. Time sought for these things happened, and I was briefed recently, Lordship. Right, a change brief, Lordship. Board is the appointing authority, Lordship. Then this year, 10th to 19 December 2025, Lordship, 10 to 19 December, again, this examination happened, Lordship. Page 11 of my writ petition, Lordship. Representation to the board, followed by representation to the
Let me hear the school.
Lordship.
My lord, we are a government approved school, my lord. We are getting, my lord, the aid with regard to salaries, my lord, and my lord, other stationaries, my lord. Apart from that, all expenses, my lord, have to be borne, my lord. We, my lord, give this, my lord, we take permission, we seek permission from the authorities, my lord.
Show the
My lord, your lordship, my lord, for that reason, my lordship, kindly acknowledge me. I have been told, my lord, over phone, that we had sought for a permission, we have written to the authorities, my lord, for examination, for conduct of the examination, because, my lord, we rent them, my lord, the terrace, my lord, where, my lord, the exams are taken place, my lord. We get an amount, my lord, which we use for the betterment of the school and, my lord, students, my lord. Because, my lord, the electricity charges, miscellaneous expense has been borne by us, my lord. We are not being given a single farthing with regard to that, my lord.
And how much do you collect from the students?
My lord, no, my lord. We get it from the cost accountant institute, my lord. They give us, my lord.
Your students, do they pay fees in the school?
That
or you impart education free of cost?
My lord, that
Sponsored school.
sponsored
Government
school.
sponsored school.
Government sponsored.
Yes. Do you charge even in government sponsored school
Yes,
fees
yes,
are
200
collected?
200 টাকা বোধহয় হচ্ছে charge, 200
They,
250 টাকা।
you,
That I have to, that I don't. Casually, students are decreasing day by day, Lordship, in a huge amount, Lordship. This is the main reason, Lordship. No education.
how many classes are there?
Up to 12, as much as my sister.
Higher secondary
Lordship,
school?
11, 12, Lordship, this 10 to 19 December 2025, examinations were conducted alongside the 11, 12 classes also happened, Lordship. Can you, I mean, is it imaginable, Lordship? I ask it to myself.
My lord, may I show your lordship, there is a notification of the government in 2018, that is as page 14 of the supplementary affidavit, which says that the school or the schools are directed, my lord, may I read? It has come to the notice of the competent authority that buildings and
No, I have
infrastructure.
read it.
Yes. So, my lord, this is apart from education purpose, it cannot be used. So, my lord, lot of schools, my lord, which I know about it, my lord, this is used for this education purpose, examination holding and all. And lordship will find one notice at the last page, page 25, where, my lord, the school authority have asked the teachers to give their consent whether they are aggrieved or not. My lord, kindly see your lordship, page 23.
Yes.
That is the typed copy. 24 is the handwritten copy. So, my lord, here lordship will find in the handwritten copy, my lord, there is a consent of all the teachers.
Not all the teachers, or no is also there, Lordship. Many no's are there. In 23 type copy, your Lordship will find.
Well, school premises cannot be used for other purpose.
Take
No.
steps.
My
Why
lord.
are you not taking
Yes,
steps?
DI. Why DI is not taking steps?
Because one specific representation there.
Representation is already there.
Copy to.
What
Direct,
copy to?
only director.
No, please, but
No. Board will not dictate. It is a DI. School is running directly under the DI.
Competent authority, it should go from, it should, henceforth all institutions shall refer such cases of the use of school infrastructure for non-educational purposes to their superior authorities, who in turn shall refer the same to the school education department.
He's for
So,
education department.
Mala, if
you
the
got to
fresh
take
presentation
steps.
is submitted
Why fresh?
before the concerned
Why
DI.
fresh? The old one is already here. Why fresh?
Then as your lordship, my lord.
I'm grateful. Lord.
The director of school education is already there.
Yes, Lordship.
District Inspector of Schools, representation was served.
Yes, Lordship. Page 15 of the writ petition, Lordship.
Please come. The petitioner claims to be an approved teacher of a government-sponsored school. She alleges that the school premises is being used for non-educational purposes upon acceptance of rent. It is further alleged that the studies of the students are being hampered because of such activity. Representation filed against such illegal activity has not been considered till date. The petitioner refers to the order of the Commissioner, School Education Department. School Education Directorate, dated 18th of December 2018, whereby all schools have been directed to refrain from doing any activity which negatively impacts the pedagogical interests of the students studying in the schools. The said government order specifically bars use of these school premises for any other purpose apart from education. Page 14 of the supplementary. No, online.
Supplementary. Be avoid. Be avoid. Be avoid. Be avoid.
Learned advocate representing the school submits upon instruction that the rooftop of the school premises is being let out for conducting examination upon acceptance of rent. Stop. The money received is being used for the betterment of the school and its students. Stop. It has further been submitted that the other teachers have given their consent for such letting out of the school premises. Stop. Paragraph. The school is directed, the head of the institution of the school is directed to file a report by way of affidavit disclosing the number of days for which the school building was let out for other purposes and the details for which the same was let out. Stop. The money collected on account of rent for letting out the school premises shall also be clearly mentioned. The whether any accounts are being maintained by this school in respect of the money collected on account of rent shall be mentioned. Stop. The manner in which the money collected is being utilized shall also be placed in the report. Stop. Paragraph. The report shall further disclose the number of teachers, non-teaching staff, and students of the said school. Stop. The permissions obtained by the school from the competent authority for letting out the same shall be annexed with the report. Stop. Paragraph. The District Inspector of Schools, Secondary Education, Kolkata, is directed to file a report disclosing whether any permission was ever sought for from the school authority for letting out the school premises for non-educational purposes. Stop. The DI shall disclose in the report the basic statistics of the school, namely the number of teachers, non-teaching staff and students. Stop. The the report of the aforesaid respondents shall be prepared and circulated within a period of 6 weeks. Reply, if any, be filed within a fortnight thereafter. Stop. List the matter for further consideration on 16th March 2026.
I'm grateful. I'm grateful.
16th March. Deeply obliged.
Supplementary affidavit filed in court today be retained with the records. Filed today by the learned advocate for the petitioner. Yes, next.
Yes.
At item number 20, I am for the petitioner.
school. Yes.
একটা group C
হ্যাঁ,
clerk,
এখানে স্কুলের বক্তব্য আছে সেখানে যাবে।
group C clerk seeking transfer on general ground pending before the commission.
Show
Page
me
20.
please.
Page 20. Page 20. Pending before the commission, general ground.
Yes. Disposed. Service taken on record.
21 ওই ইনস্ট্রাকশনটা আছে যে বিলো র্যাঙ্ক
কালকে কমিশন লিখেছিল, আপনি কমিশনার অফ স্কুল এডুকেশন করে দিয়েছেন।
At 21, I am for the petition.
ঠিক আছে, পেছনে লেখা আছে।
Assistant teacher transfer on spouse medical ground pending before the commission. Page 31 is the extract below.
This matter also we have the specific instruction, but let the same order be passed.
Spouse medical
Spouse
ground
medical-
pending before the commission.
Yes, but rule 640 is there in medical ground transfer.
Yes, disposed.
Great. 22, I am for the petitioner.
22, I am for the commission.
But petitioner in the year 2022 applied on transfer on self medical ground. But it has reached to the DI, and DI, after conducting the medical verification, it has been rejected on the ground that CMOH is not affirmed the seriousness of the medical condition. Now, my lord, petitioner challenged that order, but because my lord, petitioner is really facing some medical issues, and this, my lord, this gap, my 2026, but health condition of the petitioner is deteriorated. So since no application is pending, let the petitioner give given liberty to file a fresh application on medical ground. And
The petitioner seeks transfer on self-medical ground. Stop. The earlier application made by the petitioner was long back. Stop. It has been submitted that
51.
Recently the petitioner is suffering from various medical issues and he is liable to be transferred. Stop. As it appears that the petitioner is yet to apply a fresh seeking transfer on self-medical ground, accordingly, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to file application seeking transfer. Stop. In the event such application is made, the same shall be considered by the school authority in accordance with law at the earliest. Stop. The fate of the petitioner's application shall be made known to the petitioner.
And well, only one line. If cannot succeeded, all consequences.
If the
Let him apply. Let him apply.
Yes, yes. If the prayer of the petitioner is allowed, then necessary consequential steps shall be taken by the head of the institution. First, the barrier of medical checkup is there.
Yes, yes.
Then
23 তে আছি তো আমরা। পরেরটা লক্ষ্মী। 23 minute time for the petitioner. Transfer applied for transfer on spouse medical ground pending before the commission. That page 19 is the extract. But at 8th of July 2022, it has been referred to the commission.
I am appearing for the commission led by Dr. Patra, my lord.
That I am for the status now.
আমিও বেরিয়ে যাবো দাঁড়িয়ে গেলাম তো
Pending before the
একটা চা খাওয়াবি কি আছে?
spouse medical.
yes, disposed.
এখানে এখানে শেষ।
Yes, state response.
My lord, I am for the petitioner, my lord. Yesterday I was very sorry. 24. But আপনি তো
24 I am for secondary board leader.
না না স্কুল অফ কেমন joined in the school on compensation ground on 4/5/2006. Thereafter, he continuing in service up to 2013. And he meted with a serious accident. Therefore, he paid for transfer, then transfer. But that was not considered. He moved before the High Court. High Court passed an order to the HM to pass a necessary no objection certificate. That was not done. In the meantime, he was
What do you want now?
He has been
Already
he has been
retired,
retired.
Lordship, claiming
Yes,
the retirement
31st of
His
July
suspension order
23.
has been revoked by the, that is annexed page 66, my lord, if your lordships come. না রিলিজ করেছিল তো page 66, my lord, it is the order of my lord justice
Whoever it is, 2019, the order is agree with not taking steps to releasing the area salary.
his suspension order was finally quashed and set aside by the West Bengal Board of Secondary Education. Therefore, he is entitled to get the salary and arrears as well as suspension allowance. And that has been granted by the DIF schools at page, my lord, kindly,
He's allowed 82, 82, 83. He's allowed.
82, 83, my lord. No, the 81, 80, 81B.
The managing committee teacher in charge are directed to forward all papers pertaining to the arrears salary. The DI shall consider the same and if he thinks fit shall release. Consider he entitled to any other amount. So the court never allowed it. The court forwarded it to the DI for taking a decision in the matter.
And that report is 81 page, my lord. Page 81.
81.
Here claim of in favor of Bonnie Amin versus such and such. To
81A.
81.
Yes, 81.
A.
81A.
আচ্ছা ঠিক আছে ঠিক আছে
Page
Page 81.
81A.
81A, my lord. Yes, with reference to the above, this is to inform you that the area salary claim in favor of the Bonnie Amin Group D staff, Nimtala DMT school post such and such, subdivision from 1/1/2014 to 28/2/2019 had been verified, and observation raised by such and such was informed to me by the school authority by office number such and such for complying with the 24/4/2019. The school authority complied the observation and complete necessary documents such and such from the documents. Such and such, my lord, kindly come to the next page. Last 81B. In the above mentioned, last paragraph, in the above mentioned circumstances, the area claim in favor of such and such the group D
The ADI forwarded it to the DI. Then what happened?
Yes. DI has rejected.
No, don't see.
Page
138.
In the petition is not entitled to area salary, rejected. Right. Then
Subsequently, I filed contempt petition.
contempt.
Yes.
How is contempt
That
maintainable?
order has been passed. কত জানি contempt এর?
138 you say?
Page, my lord,
You requested to take appropriate step.
94.
95.
94,
95.
94, 95.
Where is the last order?
Last one, 138, Lordship.
138 you are requested to
Time
take
that is
appropriate.
school authority to take action. 140 school authority already take action.
Take action.
Yes, he did not physically present. During the time of preparing of the papers is a must. Signing is necessary.
That is for all.
Try to understand one thing. You served in the school only from 2006 to 2013. How are you entitled to your terminal dues?
Minimum 10 years service.
Then
that is a rules permit.
Please come. The petitioner.
After all, my lord, whatever the amount.
Terminal dues. Stop. It appears from records that the petitioner was appointed on compassionate ground on 4th May 2016. Stop. He performed his duties till 10th December 2013. But thereafter, he met with an accident and was unable to attend his duties. Stop. He retired from service on attaining his normal age of superannuation on 31st of July 2023. Stop. The petitioner approached this court on earlier occasion, seeking direction upon the respondent authorities to take steps to release his dues for the period he remained absent. Stop. The authorities consistently held that as the petitioner remained absent for more than 5 years at a stretch and remained absent for more than 5 years. Remained absent and did not perform his duties uh, after December 2013. Accordingly, he would not be entitled to any terminal benefits. Step next. The learned advocate for the petitioner has not been able to produce any supporting law which permits grant of terminal dues in respect of an employee who performed service for a little more than 6, 7, 8, 9, 10, 11, 7 years. Stop. Next, in view of the above, the relief prayed for by the petitioner cannot be allowed. The writ petition fails and is hereby dismissed. Supplemented affidavit filed by the petitioner be written with the records. Next. Yes.
This is that matter, my lord, where I challenge the action of the respondent, my lord, in refusing my prayer for compassion appointment.
Oh, this is
That
you
matter,
have concluded your arguments.
Yes. My lord, this is where, my lord, we challenge where we challenge, my lord, the rule of this compassion appointment. A specific explanation in the bias of that particular specific explanation. But what happens in this meantime, I just request your lordship that I will not, my lord, press on this challenging of the bias, this particular explanation anymore. I will be only, my lord, making a submission, my lord, with respect to, my lord, the rejection, whether, my lord, that was right or not.
Page.
If I request your lordship, my lord, to see the rejection of my application for compassion appointment. Page number 41, my lord, can you see one?
Yes.
Your lordship will see that the second paragraph, it's a 14th of August 2018 communication. So, my lord, the second paragraph of this one goes as, her ward has been receiving the family pension per month according to the PPO issued by the DPPG West Bengal, basic pay of such and such, plus DA, plus interim relief, plus medical allowances. So total is 25,000 and odd. Then less 40% of the total pension, which is such and such. So the total is 15,000 and odd. So 15,000 is or 18,000 is more than 12,000, which is the income of the group D staff of the state. So this is why it was rejected. So I initially, my lord, challenged this provision that it should not have been, my lord, measured in this way. But my lord, lordship can is fact remains in this rejection. Your lordship will see in my pension, my lord, the component of DNS allowance, interim relief, and the medical allowances have been, my lord, calculated. So, my lord, the rule specifically says that here only, my lord, the basic pay that should be there. So all other components will not be taken into consideration while calculating this particular part. So, my lord, this is already held by this honorable court, by the honorable division bench of this honorable court. And pursuant to that, my lord, my prayer before your lord, if I take your lordship to that once. My lord, the rule I have annexed, if your lordship, and in the division bench also, my lord, the rule is quoted. Here the similar situation, my lord, came.
Yes.
So there, your lordship will, in financial hardship, this was, my lord, quoted, your lordship has seen. So there, my lord, in paragraph number 3, internal page number 2, my lord, it is said that on a plain reading of the said rule, it appears that the computation of the income of the family provident fund, gratuity, and 40% of the family pension of the first 7 years shall be excluded. We are not referring to other portion of the said rule, as they are not relevant for the present purpose. The question arises whether dearness allowance, medical allowance can be treated as part of the income of such family. The rule has clearly stated that if a family member has an income earned from any other source other than provident fund, gratuity, and 40% of the family pension, that could be taken into consideration in addition to 60% of the family pension earned by the members of the deceased family in determining the financial hardship. The rule has not been amended, unlike the Government of West Bengal's Labor Department circular. The total family, which says that the total family pension per month does not include the basic pension, dearness allowance, and the medical allowance. The said scheme is beneficial in nature, and the court should not ordinarily read into the rules, something which was never intended or expressly provided. The rule has to be read keeping in mind the object of the said rule. On such consideration, we set aside this order. So, to substantiate my argument, if I just could take your lordship to the order which is passed in the content in this matter.
Show the rule once. Yeah. Rule.
The rule, I have annexed, your lordship will see, starts from page number 42. And the relevant part of the rule, if I directly take your lordship, would be
Rule 20. Schedule 5.
Page 50.
Chapter
Page number.
4,
Page number.
page number 50.
Yes.
So, it says the selection of non-teaching staff on compassionate ground. 20, it says manner of selection of compassionate ground. Notwithstanding anything contained in these rules, the concerned DI schools secondary shall maintain a roster of the candidates seeking appointment on compassionate ground as per the procedure laid down in Schedule 5 and forward the name of the respective regional commission. So, now if I request your lordship to see Schedule 5, which your lordship will find at page number
51.
At page number 56. 56 at the bottom.
Yes.
So, it says, has your lordship got this?
Yes, yes.
It says that procedure, manner or of application and preparation of panel for appointment on compassionate ground. Then my lord kindly sees here it says when the teacher before the date of 60 years leaving a family which is in the opinion of the district inspector of the schools in such extreme financial hardship that it fails to provide 2 square meals and such spouse, son, and daughter. Then I'll skip it over. Then my lord kindly turns to the next page. My lord sees the explanation. So explanation says the expression financial hardship in relation to income of a deceased teacher or non-teaching staff consisting of up to 5 members in the family shall mean an amount of income less than initial gross pay of group D staff of the state government at the material point of time. For computation of income of such family and income of an amount earned by each family member from any other sources than provident fund, gratuity, and 40% family pension of the first 7 years or upon the attainment of 67 years or age of the deceased teacher had been alive, whichever is earlier, at the material point of time shall be taken into account. So by saying, my lord, here I tried to make an impression upon your lordship that only our pay without the component of DA or medical allowances or interim relief should be taken into consideration, no other thing.
DA is not mentioned. It is only the provident fund, gratuity, and 40% of family pension.
So, my lord, the observation of this honorable court has been that since it is not mentioned, since it is a beneficial, my lord, legislation, then they cannot include this in the component of calculation of this family pension of 40%.
Family pension per month, basic pay, 13,520. Your basic is 13,520.
More than the.
No. My basic, wait. My lord, basic pay is 13,520.
Right.
Then 60% of the same will be calculated. Lordship, if it is 13,520, 61 of 40, right? 60. 60% of 13,520 would have been much lesser. If I
Where is the 60% coming in?
40% will not be calculated.
40% of the family pension?
Yes, will not be calculated.
Will not be calculated.
50% will be calculated.
Yes, family pension, but the basic is 1350
Yes.
DAIR
The DA interim relief or
total
medical allowance would
less
not have been
40%
calculated.
is 10,000.
Yes.
Right.
So otherwise,
So the total is 15. 15.
the calculation I have just sorry. My learned friend my lord, has prepared my lord, a small note where my lord, if I request your lordship see paragraph number 4 once. The calculation would be much clearer over there. My lord, if the total income of the 13,000 to 500.
Yes, 13,520 is there.
Yes. So if
60%
60% of that would have been taken only without my lord adding this component of DA and MA and IR, it would have been my lord 8,000 and odd. And with 8,000, the other income which is said to be 3,000 could have been added, then it would have been 11,000 and odd.
What is the other income that you have?
My lord, other income.
The husband is getting the family pension. He must be getting this pension also, or otherwise working.
The pension cannot be taken into consideration for purpose of compassionate appointment.
My lord, it is already settled in bulk.
That is separate. Right. So the
so this my only grievance to your lordship that they could have, my lord, considered my case without, my lord, adding this component because it is not specifically mentioned in the rule that it should have been added.
Ajay, please come.
I'm sorry.
The petitioner seeks compassionate appointment. Stop. Petitioner is him, her, he, she, what?
She.
No.
The petitioner is the son of the
Guru Nabu.
deceased teacher.
His prayer stood rejected by the District Inspector of Schools, Secondary Education, Howrah. With a communicating memo dated 14th August 2018 with the observation that the family income of the petitioner is more than the gross salary of a Group D staff of the state government at the material point of time. Stop paragraph. The gross salary of the Group D staff of the government at that material point of time was rupees 12,510 per month. Stop. For the purpose of calculating the family income of the petitioner, the District Inspector of Schools took into consideration the dearness allowance, the IR is interim relief. Where is the provision for interim relief? I do not know. Anyway, interim relief and the medical allowance, and arrived at a finding that the said amount is more than the monthly salary of Group D staff of the state government. Stop. The petitioner is aggrieved by the same. Stop. Reliance has been placed on the West Bengal School Service Commission, bracket open, selection of persons for appointment to the post of non-teaching staff, bracket close, rules 2009. আচ্ছা ওটা হবে rule 20 of the said rules, which lays down the manner of selection on compassionate ground. Stop. The provision lays down that for ascertaining financial hardship in relation to income of a deceased teacher or non-teaching staff consisting up to 5 members in the family shall mean an amount of income less than the initial gross salary of Group D staff of the state government at the material point of time. Stop. For computation of income of such family, comma, income of an amount earned by each family member from any other source than provident fund, comma, gratuity, and 40% of family pension of the first 7 years, or upon the attainment of 67 years of age of the deceased teacher, had he been alive, comma, whichever is earlier, comma, at the material point of time, comma, shall be taken into account. Please come to page 41 once more.
Yes, madam.
The authority took into consideration your DNS allowance, interim relief, and the medical allowance.
Madam.
Suppose you deduct all those, then also it remains 13,520. That's your basic, right?
Yes.
Then less is 40% of the total pension. It is
It should have been calculated on 13,000 and all, not on 25. This could have been valid.
8,000, you say?
Yes. It comes
Right. The rule that you are relying upon, it mentions that the amount on account of provident fund, gratuity, and 40% of family pension cannot be taken into consideration. The authority did not take into consideration your provident fund and gratuity.
It's not even my case.
Right,
Then take into consideration, they calculated, my lord, 40% in the name of family pension. They calculated, my lord, DRNS allowances as well as interim relief as well as medical allowances, which they are not supposed to do.
Under which provision of law?
But on the provision, my lord, which I have relied upon before your lordship, which says that it doesn't talk about this. And this has been interpreted by this honorable court. That is what I was just trying to assist your lordship.
The interpretation of the division bench, please see.
But it is not specifically said that interim relief or DA or MA should have been, my lord, calculated. So this is why, since it is a beneficial legislation, my lord, that should not be incorporated also. So this is what, my lord, subject to your lordship's correction, my lord, has been, my lord, said by the honorable division.
Paragraph number 3 of the
Yes.
division bench's
On a
judgment.
plain reading, may I please?
Yes,
On
please.
a plain reading of the said rules, it appears that for computation of the income of the family provident fund, gratuity and 40% of the family pension of the first 7 years shall be excluded. We are not referring to other provision of the other portion of the said rule, as they are not relevant for the present purpose. The question arises whether dearness allowance, medical allowance can be treated as a part of income of such family. Same, my lord, here. The rule has clearly stated that if a family member has an income earned from any other source other than provident fund, gratuity, or 40% of the family pension,
None of these have been taken into consideration for your case, neither provident fund nor gratuity.
yes. Other than
Then
that means, my lord, if
that means dearness allowance comes in.
no, my lord, no, I tell you, lordship, it is on the income of any other sources. So, my lord, there is in any other source they have calculated it to be 3,000. Be that as it may. In any other source, any other income from any other sources, rather than provident fund, gratuity, and 40% family pension would be calculated in any other sources, which is not done. So, my lord, they, while for the purpose of calculation of family pension, have added this component of dearness allowance and the medical allowance, which the honorable division bench says they are not permitted.
No, it's not becoming clear. 1 second, please.
Sorry, ma'am. The question arises, may I once again, read this?
Yes, please.
The question arises whether dearness allowance and medical allowance can be treated as part of income of such family.
Right.
The rule has clearly stated that a family member has an income earned from any other source
Other than
PF, gratuity, and 40% of family pension.
Right.
That could be taken into consideration in addition to 60% of the family pension earned by the member of the deceased family in determining financial hardship.
So what does this mean?
That means, my lord, anything than this 40% of family pension, the gratuity, and the provident fund will be calculated as income from any other sources. Anything except these three will be calculated under the heading.
The rule doesn't say so.
But rule says that these three will be calculated will be deducted or
Will be deducted.
Yes, will not be taken.
They have not taken into consideration these.
While calculating this 40% of the family pension, took into consideration three other components and added it into the family pension. So what if I thereafter, my lord, go on, my lord, reading this. This rule has not been amended. Let us skip this. The said scheme,
Yes,
page number 3,
is
the said
beneficial.
scheme is beneficial in nature, and the court should not ordinarily read into the rules something which was never intended or expressly provided.
Yes, so how can the court read into this that it cannot be done? Dearness allowance is nowhere mentioned.
My lord, see, the dearness allowance is previously mentioned in the previous paragraph.
In the rule, dearness allowance is not mentioned.
Not mentioned. So this is what
That means the court is reading something which is not there in the rule.
I tell you, lordship, the honorable court says that the dearness allowance, it is not written in the rule.
Yes.
Dearness allowance, the authority ought not have calculated the dearness allowance in this because it is not written in the rule. So thereafter, my lord, kindly sees, if I'll just take your lordship to this. The said scheme is beneficial, sense that the rule has to be read plainly without importing any word, and in case of any ambiguity and interpretation favoring the applicant should be accepted, keeping in mind of the object of the said rule. Now, my lord, if I request your lordship, see the contempt order in this matter. Just hand it up to your lordship. There your lordship will see, my lord, straightway paragraph number 3. Mr. Chattopadhyay has admitted that in our order, dearness relief and medical allowance have been clearly excluded. Once we have clearly excluded the said two components, the DI had no authority to deny the claim of the petitioner by taking into consideration the said two components, which is clearly contemptuous. So here also, my lord, there perhaps, my lord, there could be, my lord, any ambiguity that could occur, and thereafter DNS allowance and this D and MA was
আচ্ছা আসুন তো দেখি The petitioner also relies upon the order passed by the Honorable Division Bench on 17th January 2024 in MAT 1664 of 2023, Can 1 of 2023, and একটু দেখে নেবেন Bitashok Mahata versus State of West Bengal and others, and the order dated 26th July 2024 arising out of the contempt proceeding in the aforesaid matter being CPAN 864 of 2024 in MAT 1664 of 2023. Bitashok Mahata versus Piyush Kanti Bera. Reliance has been placed on paragraph 3 of the order dated 17th January 2024, wherein the court was of the opinion that DNS allowance and medical allowance cannot be treated as part of income of family pension. Income of family for calculating the family income of the family. Now, family income for determining financial hardship. Stuff. In the contempt proceeding, the court clearly laid down that DNS relief and medical allowance would not be excluded. DI has considered two components, DNS disregarding or direction, as we clearly read that in the absence of any amendment, DNS could not be excluded for the purpose.
There is a mistake. Kindly skips it over. Then Marat comes down.
The DI has to go beyond and make
That is there, my lord. That is there, but my lord, it is typographical error, my lord, subject to your lordship.
That has not been corrected.
That has not been corrected.
But kindly see paragraph number 3. Then
Contradictory.
But that would be evident from paragraph number 3. My lord. That
Absolutely contradictory. কি বললাম বলুন তো? Now, clearly took note of the submission of the learned additional government pleader that DNS relief and medical allowance have been clearly excluded. And once the excluded, stop. The court held that once the aforesaid two components have been excluded for calculating the family income, comma, the DI had no authority to deny the claim of the petitioner by taking into consideration the aforesaid two components. It has been submitted that if the family income of the petitioner is calculated by excluding the component of DNS allowance, comma, interim relief and medical allowance, comma, then the monthly income of the family will be less than the salary of a Group D staff of the state government at the relevant point of time. Yes, sir. Reliance has also been placed on the judgment passed by the Honorable Supreme Court in the matter of Balbir Kaur and another versus Steel Authority of India and others, wherein the court laid down that but this is only regarding Provident Fund, isn't it? They have not taken into consideration the Provident Fund account, so it's better to omit it. Prayer has been made to direct the District Inspector of Schools to recalculate the family income of the petitioner for the purpose of providing compassionate appointment. The paragraph. Yes, what will be a submission state?
Lordship. The family income that has been shown at that relevant point of time, the salary of the Group D staff of 12,510. That also includes that DA and medical, all that, including all that, the income of the Group D staff. If that is to be deducted,
as it appears that the Honorable Division Bench of this court has held that the dearness allowance and the medical allowance cannot be calculated for ascertaining family income of the family for the purpose of providing compassionate appointment. Accordingly, the impugned order of rejection holding that the income of the family is more than the salary of the Group G staff of the state government does not appear to be proper. Stop paragraph. The impugned order of the DI of schools dated 14th August 2018 accordingly stands set aside. Stop. The District Inspector of Schools, Secondary Education, Howrah, is directed to recalculate the family income of the petitioner strictly in accordance with law and in line with the order passed in the matter of Vitoshok Mahata within brackets Supra. Steps shall be taken in the matter at the earliest, but positively within a period of 6 weeks from the date of communication of this order. A final order shall be passed and communicated to the petitioner immediately thereafter. Each petition stands disposed.
thank you.
I'm for secondary board, Your Lordship.
Please take the microphone.
My lord, I am for the petitioner led by Mr. Sudipta Panda. He is not well today, so I am praying for not today.
Only not today? What is the matter?
Well, this is a matter of change of name. The petitioner was passed in 94 as Jagannath Mitra. In 2020, change as that matter.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Released on 2nd of February 2026. Next, record board's appearance.
27, I am for the petitioner.
On
This matter, Lordship may remember, I am challenging the list of Group D, Group C, my lord, allegedly tainted candidates on grounds. On the last occasion, my lord, I had prayed that my lord, commission should take a stand in respect of this Group D, Group C candidates as to whether they have included the candidates who were there in the expired panel and whether they have included their names or not. Now, my lord, I will try to substantiate as to the, my lord, Lordship is, my lord, taking up the matters. My lord, there are several matters. By now, my lord, the Supreme Court order is by heart. But, my lord, I would like to substantiate, my lord, and show what was the basis of the orders and what were the, my lord, the divisions of categories. Because I am trying to substantiate before a lordship that the Honorable Division Bench, in order, Division Bench, my lord, presided over by Honorable Justice Shen, has been pleased to, my lord, categorize as to who would be construed to be tainted on these three. First is the persons who have been appointed after expiry of the panel. Second is persons who have deposited the blank OMRs. Third is, my lord, the persons who have, my lord, the expired outside panel, expiry panel, and blank OMR. Now, my lord, I'll try to substantiate who are these persons, from where these findings have been arrived. That is why, my lord, on the last occasion, I have drawn your lordship's kind attention to the order of the Honorable Supreme Court, my lord. If your lordship wants, I can again, my lord, draw, but good, bad, indifferent, lordship has not yet called for any report. My lord, if anything is passed, it can be said that there has to be an opportunity given to them too. But only one thing, my lord, even if your lordship, because the matters are fixed on 13th, I think, with regard to the teachers.
It is staggered way it has been fixed.
Yes. So therefore, these questions will come. If they come and say that, yes, we have included the expiry panel candidates in this list, then the question would arise as to why you have not included the expiry panel candidates in the teachers list.
Here is
Group C, Group D.
Group C, Group D, and the expiry candidates appointed after expiry of the panel has been treated in the tainted list?
Yeah, I don't know. That is what they have to come up with a stand. My contention is that they have not included. If they come, my last paragraph 5 was, prayer has been made to direct the commission to produce the list of candidates of Group D,
And
Group C.
it's been passed.
No, it has
just 2 days back, possibly directing the commission
yes
to come up with a panel for the teaching staff.
teachers,
Staff.
yes.
Same principle will apply here also.
Now, my lord, if it appears that they have included the expiry panel candidates in the tainted list in respect of Group D, Group C, then they have to explain as to why they have not taken the same stand in respect of the teachers. Because paragraph 31 of the Supreme Court is same.
No, as of now, whether the candidates who were appointed after the expiry of the panel have been included or not, you do not know.
Yes, because it has to, they have the documents, they can scrutinize, because paragraph
requirement of coming up with a fresh panel is also this.
In my instruction, insofar as Group C, Group D is concerned, that no one was appointed after expiry of the.
Oh, let it come on record then. I'll substantiate.
That is number one. That is my first submission. Insofar as the issue that is being sought to be canvassed before your lordship, we are covered by this judgment in respect of teachers, where Mr. Lahiri also had the occasion to appear.
That I'll show. I have annexed everything. It is there. It is the first matter. There, my lord, the teacher's issue was that first question was what put to me by the court was
better that you file a report. What are the issues primarily?
Primarily issue is I am challenging the
list,
saying that persons who should have been included have not been included, and persons who should not have been included, like us,
the
have
list
been
has not been properly prepared.
Yes, list is challenged. It may be in both ways. That is, my lord, Sompakos order, my lord. I have annexed that, my lord. That is distinguishable. Yes, that is distinguishable. In fact, I moved that.
Yes.
Oh, no, not this. Oh, yes. This one. Now, my lord, there, teachers matter. What was the first question put to me was, what were you doing after you were excluded on 17th May order? On 17th May, the commission went up to the Honorable Supreme Court. I have annexed the order, but lordship remembers. I will not trouble your lordship. On 17th May, the honorable the commission had approached the Supreme Court saying that we are not being able to run our institution. Kindly allows us to continue with the services of the Group D, Group C, teaching staff, everyone. The Honorable Supreme Court was of the view that since Group D, Group T, Group C, the percentage was higher, we will not allow them to continue, the teachers will continue. So from 17th May, the teachers knew that they are somewhat in the tented list. Now, when the tented list was published, when it was challenged, the first question which was put to me by the honorable bench was that what were you doing from May? Why have you come now? On that point, my lord, the single bench held against me. We had approached the honorable division bench upheld the order. But in this case, my lord, Group D, Group C candidates were all through. My lord, this is for the first time they have come to know that they have been included in the tainted list. So therefore, on facts and on the place, the order, if your lordship sees, that is the reasoning of the order passed by the honorable single bench. I have annexed the order of the honorable division bench. I can draw your lordship's kind attention, my lord, quickly to that part. So therefore, teachers' matters is totally distinguishable.
The petitioners allege that
Only one part, my lord, if your lordship is of minded of directing filing of report, they should specify as to whether they have included the expiry panel candidates in this list or not. Other reports, yes, they have the right to, my lord, say whatever they like, but this point has to be clarified. Because if they say that we have not included, one kind of argument. If they say they have included,
because this is the document. In 2019, this is the document. The panel expired. We have not appointed anyone from the expired.
Let this come on record. I will not go into oral arguments.
This must be there in the website.
Yes, it is there in the Supreme Court. It is there, my lord. I have, my lord. It is there in this 11,000 compilation. This was
that
there.
Panel and waiting list
Expired.
in relation to third RLST for recruitment of such and such expired on 18th May.
Yes, lordship has been handed over a document of 2nd September 2019. It was there before the page 2463.
So
let them say whatever they want. Let it come on record so that I can deal it. They have to take a stand.
When was the list of tainted candidates in Group C, Group D published?
Group C, Group D, the impugned list. The impugned list, my lord, if your lordship sees, will not, if your lordship sees, there is no date. But, my lord,
3rd November.
It was published on 3rd November, yes. Same footing like us.
কিছু বলেছিলাম
What's the page is called?
the petitioners
সরকার পেজ খাজনা পেয়ে গেছে খাজনা পেয়ে
the petitioner ঠিক আছে the petitioners challenge the list of tainted candidates in respect of Group C and Group D for recruitment in 2nd SLST 2025. Specific submission is that the list has not been properly prepared. The candidates whose names ought to have been included in the list have been illegally and arbitrarily excluded.
Expiry and others, yes, that is my submission. That is my sorry.
The candidates who have been excluded ought to have been included in the list. Next. The list which is impugned herein was published on 3rd of February or 3rd November 2025. Paragraph. According to the commission, the list was properly prepared by verifying all details. Next. To decide the issue conclusively, the commission is directed to prepare a report by way of affidavit. the report shall mention the ground for including the candidates in the list of tainted candidates. Stuff. It should specific mention shall be made as to whether the candidate had been appointed after the expiry of the panel, or there was OMR mismatch, or the candidate was appointed out of the panel, or what are the other categories?
Three. Blank OMRs.
OMR mismatch.
These are the three categories.
This
Rank jump.
rank jump.
Rank jumping
and
is
rank
included.
jumping.
That is the point. Rank jumping is again included. Rank jumping is what? Persons who have got lesser
Lower
marks
rank has been.
So these are the persons who are out of panel who had subsequently come. These are the real culprits for which we have lost.
More than appointed than recommended.
Out of panel.
No, out of panel. Provided they will be in the panel.
Rank jump.
Insofar as one issue, expiry panel,
সেটা দেখাবো তো।
issue is being sought to be raised. And I don't think there is a government
পড়াও।
or means responding to it.
No, maybe because he challenges the entire panel. You give the category.
Seeing this from the bar.
No, I've challenged the panel.
He sees the relief platform.
I've challenged the panel.
Please come to the relief platform. I may be wrong, kindly see page 97. Where is his relief? Substantial relief paid for?
To transmit the records and the impugned list.
Yes, I'm challenging the list.
To cancel, rescind, recall the notices and the impugned list dated such and such.
And then an interim order allowing him to participate.
No, and there is some mention about the list.
I'm
cancellation of the list.
We can, with respect, but in the absence of what we have
Proper pleadings.
How can we meet an allegation?
All right, now the court has made it clear there are 4 grounds, 4 categories rather.
The court is making it.
Oh. What was paragraph 37 of that judgment? It was placed on the last day.
37 of the Honorable Supreme Court.
Appointed then recommended.
Paragraph 37 of the Honorable Supreme Court.
Yes.
Just a minute.
37 is
a discrepancy in the recommendation made by, that is the SSC recommendation and the
that begins with that.
Yes.
Finding recorded in the impugned judgment
means
regarding this recommendation made by the
excess appointment letters issued by the board.
Number of candidates recommended for appointment, then number of appointment.
আরেকটা লিখে দিন। And rank jumping and the excess appointment letters issued by the board in favor of the candidates.
Today, in Shampa Ghosh matter, if your lordship kindly falls back to that order.
Then, my lord, may I please?
No, 1 minute.
The order.
This order was passed on 2nd of September. Your list was published in November.
True. Let us look at the stand of not here. It will be the same stand, more or less, apart from teacher and non-teacher. Now, please come to paragraph 11.
Yes.
Learned senior counsel representing the commission. I'm sorry.
Yes.
Submit that apart from the aforesaid 3 categories of tainted candidates as described in paragraph 363(4) of the judgment. Now, my lord, what are the categories, my lord? Your lordship will be pleased to find in paragraph 9. Just fall back.
Division.
7. Paragraph 7. In order to contend, somewhere in the middle of paragraph 7, that the petitioners are not coming under the category of tainted candidates as defined in 363(4) of the judgment. It is further contended that as per observations made by the Honorable Division Bench in the judgment dated such and such persons who had been appointed outside the panel or after expiry of panel or who submitted blank OMR ought to be treated as tainted, but petitioners are not coming under those categories. Therefore, the cancellation of their admit cards, etc., is by publication of this was not warranted. In addition, reliance is placed in the on the observations made by the Honorable Supreme Court in Boishaki, where in paragraph 31 it was discussed that it was not significant so far cases of rank jumping and direction given by the High Court to appoint candidates after expiry of the validity of the panel at the stage when the court was not aware of illegalities of appointment procedure. Based on several considerations, including rank jumping and appointment of candidates after expiry of validity of panel, ultimately conclusion was derived in paragraph 45 of the judgment dated such and such, wherein it was held that there was no valid ground or reason to interfere with direction of the High Court that the service of tainted candidates were where appointed must be terminated and they should be required to refund any salaries. It is also submitted on behalf of the petitioners that the observations made by the Honorable Division Bench in 363-4 were not interfered with by the Honorable Supreme Court in its judgment dated this. Therefore, identification of tainted candidates needs to be based on 3 categories as delineated in paragraph 363-4 of the judgment such and such. According to the petitioners, some of the candidates were allowed to continue their service, but they were appointed after expiry of the panel and their names do not feature in the list. Then, on the contrary, learned senior counsel representing the commission submits that apart from the aforesaid 3 categories of tainted candidates as described in paragraph 363-4 of the judgment of the Honorable Division Bench, dated these other categories of tainted candidates involving rank jumping and candidates identified by Central Bureau of Investigation were taken into consideration by the Honorable Supreme Court in the judgment dated such and such, delivered in such and such, supra, as it appears from paragraph 25 and 26. It is specifically submitted that the list of tainted candidates dated this was also prepared based on report of CBI indicating that there were cases of OMR mismatches and the commission found them as tainted candidates. Consequently, those candidates were included in the list dated such and such. According to the commission, categories of tainted candidates ought not to be confined to the categories as contained in paragraph 363-4 of the judgment. Honorable Division Bench judgment dated this. It is also submitted.
These are all submissions. Can it comes to the
passed by the Honorable Supreme Court in such and such, whereby the Honorable Supreme Court permitted only untainted assistant teachers to continue to function till 1st December 25. Authorities in terms of the Honorable Supreme Court such and such, after identifying untainted candidates, permitted only them to work as assistant teachers till such and such. None of the petitioners.
No, what are you trying to show?
Your ultimate conclusion.
Paragraph 18.
On consideration of egregious illegalities and fraud as found by the Honorable Supreme Court, paragraph 16, in the judgment dated this, categorization of tainted candidates as made by the Honorable Division Bench in such and such is probable categorization. There can be other good reasons for finding tainted candidates. In consideration of gamut of illegalities and irregularities found by the Honorable Supreme Court and the Honorable Division Bench, it is permissible to infer that there are different categories of tainted candidates beyond the stipulations contained in this 363-4 of the judgment of the Honorable Division Bench. Today it is submitted on behalf of the Commission that as per the CBI report, there are cases of OMR mismatches and the candidates involved therein are identified as...
It's all right. So nothing...
Paragraph 18, please see paragraph 18.
I've seen it.
Yes.
Please see paragraph 18, but at the same time,
moreover, not a single petitioner before this court was permitted to function. That is the point.
Yes, yes.
They are not functioning.
No, we were not functioning.
Names are there in the list.
Yes.
Point in the division bench was from 17. Why did you skip tight? Sit tight, and thereafter it was subsequent.
21.
Pending consideration.
Yes. Now it is not. Now it has been given. It is after the order.
Containing names of tainted. Therefore, this court finds these are not fit cases that court the list.
Right.
List of teachers, non-teachers. Teachers.
Doesn't matter.
And this was while Vivek Paria was pending. Now it has been remitted.
So the categories have been mentioned. Such report shall be prepared and circulated. By 4 weeks will be all right with you?
My lord, kindly keeps it on 13th, my lord.
No, by 13th it is not possible.
13th means?
13 with the other,
Wednesday.
no, not this, no. Other batch of writ petitions are there where Lordship is considering the expiry panel, my lord.
No, these are coming on staggered basis. I have fixed matters in
No,
February
25th,
also.
2nd also.
February also.
7th also.
Yes, there are matters I have figured. Even February matters have
10th,
been
10th
fixed.
February.
Because arguments would be made by me if I find from their affidavit. There will be subsequent arguments. Now
Okay, let them prepare.
also another submission can you record that it has been submitted that they have not appointed any person after expiry of panel. Very important
What is
submission.
the use? They'll file it. Recording submission will not do. They'll come up in
Okay,
by a
let it come on record. If they do not
by
say,
way
then
of affidavit.
yes.
Yes. Today is 9th. I give you 4 weeks time, so it's 6th of February.
4 weeks.
Reply. 1 week will be all right.
Yes.
13th.
I may not even use the reply.
The list 23rd of February.
You're not fixed on?
23rd of February.
And my lord,
Cat
one
5.
point, my lord.
Lordship, can 1 to 4.
Huh?
1 to 4 of the addition of party application.
Addition of party.
These are all addition of party.
Do you fall in the same line as that of the
They are saying,
petitioners?
they are saying so.
Or you are challenging?
No, Lordship, we are the
Same?
Same.
Acha.
1 can 6 has been filed today, my lord. It has been served. And
SJ 6. That is also in the same line of the petitioner. Acha. 6 connected applications have been filed seeking addition of party. Stop paragraph. As it appears that any order passed in the instant writ petition may have an effect on the applicants. Accordingly, all the applications are allowed. Stop. Can 6 is not in the days list. The same is treated as on days list and stands disposed of. 6 of 20, 26 hobe. 26 of. And the department is directed to add the names of the applicants as respondents in the cause title of the writ petition.
Let this be done by the advocate and record because department will take.
No. Don't worry. The department is working at very fast pace.
Good.
Take this document back.
Another thing, my lord, let it be
You can
clear among
back
us.
also.
My lord,
this is annexed, he
but
says.
I don't want to, my lord, pardon the records by annexing everything. I'll be relying upon the judgments of the Supreme Court and of this honorable court, which I'll give the soft copies, my lord.
Next 27.
SLS, now your lordship is taking up this. Some other group.
Now I'll take up 27.
27 is my matter.
Oh, this is 27. হয়ে গেল। এবারে 9:30 to 9:39.
So, the second SLST group may be taken up.
I do not know how the list is going to. Yes, how it will. You must be here. You are not going out. What?
Matter is being called.
Go. Somebody must be here. Yes.
Diploma.
Mr. Rahul Singh.
91, 92. ঠিক আছে।
Ashwin, in this matter, I appear for the petitioner. I appear for the petitioner, Lordship. This is a matter of interest on gratuity and arrear pension, Lordship. A petitioner retired, Lordship, on 31st October 2010, Lordship. PPO was issued, Lordship, on 12th March 2014. Lordship, an order directing to pay the gratuity was issued, Lordship, on 16th July 2016. And Lordship, gratuity received, Lordship, on 4th September 2012. PPO is at page, Lordship, 18.
The 1 minute. The payment was made when?
Gratuity received, Lordship, 4th September 2012.
All right. You retired in 2010
2010. 31st October 2010.
and you filed the writ petition in 2021.
Yes, Lordship.
And then
Then it was pending, Lordship. Since then, several times it was called on.
why will it be allowed? Yes. Yes, please. Why will your writ petition be allowed if you have filed it at such a delayed point of time? Any submission?
Lordship, may I come back on Monday, Lordship? Brotin Kumar is leading this matter, Lordship.
All right. Not today.
Much obliged.
Next.
933, item number.
My lord, I am for the petitioner. The matter deals with the interest on gratuity. Single PPO, ROPA 2019. The petitioner's mother was assistant teacher. Petitioner was superintendent from his service on 23rd 11/2016. The petitioner's mother was died on 23rd 11/2016. Petitioner's only son play for gratuity.
Gratuity?
Interest on gratuity.
When did you receive the gratuity amount?
2021. Affidavit of service were filed.
Petitioner's mother?
Petitioner's mother was assistant teacher.
Acha. The mother of the petitioner. ठीक है
Yes, my lord.
The mother was the teacher. And interest on gratuity. Single people. Yes. Disposed.
Grateful, lordship.
954, item.
Your
Kindly allow me. Yeah. Kindly allow me. I have to.
Yes, yes, certainly.
Follow.
Your Lordship, on behalf of the petitioner, this matter relates to the delayed payment of interest on gratuity, Your Lordship. The petitioner retired from a service after attaining the age of superannuation on 31st May 2022. Pension payment order was issued in favor of the petitioner on 27th March 2023. And petitioner received arrear pension and gratuity in terms of the pension payment order on 11th April 2023. Till that, no interest for delayed payment of pensionary benefits of the petitioner has been disbursed in favor of the petitioner.
So what is your prayer?
Your Lordship has been pleased to pass an order in a previous similar matter, and I most respectfully pray for a similar order in the present case, Your Lordship.
All right. What is your prayer for grant of interest?
Yes.
On account of what? Only the
delay
on the gratuity amount?
Gratuity and on delayed payment.
Gratuity and arrear.
Oh, gratuity and arrear.
Disposed.
Grateful. Your
Follow.
Lordship.
Done.
Nobody is here. Dismiss for default. এর আগেও টাইম নিয়ে গেছে, আসেনি। Dismissed. Dismissed.
9:38.
Dismissed.
9:39.
Dismissed. Dismissed. Record your appearance. 24.
After 24 minutes, he filed this.
Very well. Record your appearance. It is dismissed. Hmm.
Item number 28 from the daily list.
May it please issue, Lord. Madam for the petition.
Yes.
I'm appearing for the commission.
All right. Yes.
Yes. My lord, here, my lord, what happens? The petitioner, my lord, challenged.
Do you intend to file an exception?
My lord,
I see a recording over here.
there is a report, my lord, that has been given to me. I can just demonstrate to your lordship, my lord, in 30 seconds time that there has been some irregularity. So, my lord, the brief fact is that, my lord, there are 4 questions right now. I'm agitating to your lordships. 3 questions I say that more than one answer would have been right, and 1 question I say that it is out of the syllabus. So, my lord, thereafter when I filed this writ petition, there was a very pertinent question, my lord, put to me that whether I made this objection at the time when I was supposed to give. So, my lord, that I, by the way of supplementary affidavit, I showed that yes, I did. And there, my lord, also, my lord, if I from that, my lord, supplementary affidavit, if I just could take your lordship to what did I say in my there
Objection.
Objection, yes. Page number 6, if I could take your lordship of the supplementary affidavit.
Yes.
So there, your lordship, page number 6 has my lord got this one.
Yes.
So there, if I request your lordship, see that 1, 2, 3, 4, 5, fifth, uh, uh, fifth paragraph, my lord, it would be question number 20.
Yes.
So, my lord, that was question booklet series A, question number 20, suggested answer by candidate. More than one answer is correct. So that was my objection. Then, my lord, if I request your lordship, see, my lord, the report filed my learned senior friend's client. So, my lord, the report looks like this one.
Yes, yes.
So, my lord, second page of the report, your lordship sees. My lord, serial number 1.
Hmm.
So they say that question number 2 of series A of the master series. So they say that challenge during the objection. Petitioner suggested that the question is wrong or out of the syllabus. But my lordship has seen in the supplementary affidavit, what did I, my lord, basically object?
Question number 2 of series A.
Yes.
Question number 2 of series A. Question is wrong or out of syllabus. This is what you submitted.
My lord,
page 6.
Page 6.
At the top.
No, that is one of the objections. Kindly comes down to 4th. There are
No,
2 objections.
They have treated
only that one.
In the report, see the very first serial number is
Yes.
question 2. Question 2 is
Yes.
at the top. Question
Yes.
is wrong or out of syllabus.
Right. Question is wrong or out of syllabus. They have just regarded that objection of mine. But lordship, in supplementary affidavit, page 6, lordship has seen.
No, this is a different question. This is question number 20. The
I'm
other
so
one is question is 2.
I'm so sorry, my lord. My bad. My bad. I'm so sorry, my lord. It is page number 8. Page 20 and 2, my lord, I mixed up myself. Page number 8. I'm so sorry, my lord. Of the supplementary affidavit.
Yes.
My lord, third paragraph.
Third paragraph.
Question number 2.
Question number 2.
My lord, does
More
booklet
than
series
one
A?
answer is
Answer is correct. That was my objection.
A to D.
My lord, D was the right answer, they say.
Hey. Very outside. A 2.
Yes.
Question number 2 of series A.
Yes.
Question 21 of Masters series.
That is different. But that is
Question number 2 of
so
series
series
A.
A. Yes.
More than one answer is correct.
Yes.
Question is wrong or out of syllabus.
Yes. Now, my lord, kindly sees the fifth column, last column, expert committee review.
Hmm.
My lord, it says that answer key suggested option is D is correct on D to be correct, and then my lord, the annexure given with the report. Could your lordship, my lord, see this page where this one in the report?
Yes.
Lordship has seen this page.
Yes.
Then, my lord, it is a note sheet of the experts. Lordship sees question number 2. Options B and D both are correct. Then, my lord, comes back to the report second page. Report second page.
Report second page. Report second page, yes.
Expert committee review. The answer says preliminary answer key suggested option D to be correct.
Right.
And experts adjudicate that B was correct and option D was wrong. So that must be an inadvertent error by them. So, my lord, in the note sheet, the experts say that B and D both are correct. But while, my lord, making this chart, they say D is wrong. Moreover, I did not even say this. I said that all of them are right. That was never considered. This is one. My lord, then, my lord, kindly, I'm sorry.
Yes.
Then kindly, my lord, report internal page 2. Question number 7. Means that is the serial number 2 in report.
A report, question number 2.
My lord, the next one. Question number 7.
Question 7, series A.
Series A. It says petitioner suggested that the question is wrong or out of syllabus. Yes, I suggested that.
All right.
Then, my lord, kindly see the answer.
Hmm.
Means it says answer key suggested option A to be correct. Expert concurred with the preliminary answer.
Hmm.
So my objection was not that.
Hmm.
But the answer is said to be, the answer is correct. I did not say the answer was wrong. I said that it was out of the syllabus.
Question is wrong or out of syllabus.
Yes. Yes.
So there is no finding as to whether it was in the syllabus or the question was.
Yes.
Uh,
Yes. And my lord, the last one, I just disturb your lordship with this. The third page of the report. My lord, which is serial number 5. Third page of the report. It is question number 20. So question number 20, I said that more than one answer was correct. Then, my lord, kindly sees that it is said answer the lordship sees the preliminary answer key suggested option B to be correct. Expert concurred with the preliminary answer.
That means B.
B only correct. Or not only. If could have been written only, that could have been mitigate by grievance.
No, this can be taken to be only. This I am not.
Because this, I on the previous occasion, I was successful in creating doubt in lordship's mind by this question only. Because this was the
No,
question.
I'm not going into the question.
Yes,
the
yes.
court is not an expert, so the
Yes,
court
madam.
doesn't know.
So there
You said more than one answer is correct. The preliminary answer key said B is correct. Experts opined, concurred that B is correct, right? So this question number 20 goes.
So then, my lord, the last mine was 25, but 25 they have, my lord, I must, my lord, admit, they have correctly, my lord, indicated that I did not object at the time when I ought to object.
All right, so that goes.
That goes.
So right now only serial
and seven.
numbers A and 1 and 2,
One and
that
two.
is question 2 and question 7.
So, my lord, my prayer before your lordship at this particular juncture
How
was,
many marks short?
but I have already obtained 49 out of 60. So, my lord,
Cut off?
my lord, I already, I'm a very good student here. So I'm already through the cutoff.
All right.
So if this particular answer should have been there, my rank would have been much higher. And Lordship will kindly see that what I prayed today before this honorable court, that I said that after stating the entire thing, annexing all these documents, I already wrote to them. Kindly consider my case by seeing this, by giving this to the experts. This could have been, my lord, solved otherwise.
No,
If
but
they
then
could have
they
done
have
this-
obtained the
no,
expert's
it is
opinion.
after this, because since they have, my lord, misled by themselves, because Lordship has seen this 2 and 7. So if they could answer to this, my lord, that then also, my lord, my grievance
No,
would be
they do not have any control over the experts, and they will not be able to answer whatever is there in the report. They will follow
they
that.
will follow.
Yes.
So I just request your Lordship, my lord, they should, my lord,
Would you like to press it now, or would I adjourn it? See whether you get the job or not.
my lord, if they could, my lord, just see this, my lord, my mark would be, my lord, higher by 2 marks. By 2 marks. And they must not be having any other answer which they have, my lord, depicted here in the report. So, my lord, subject to what my lord senior, my lord, says. So, my lord, kindly, my lord, my request before your lordship, kindly, my lord, reconsider my case with respect to 2 and 7. My grievance is over.
Commission.
Can you come to the report of this?
Yes, your report only.
That is the report.
Yes, page number 2. First serial number.
Question number 2.
Question number 2.
Option B and B both are correct.
Option B and D.
Both are correct.
Where from are you reading? The chart.
No. But I am relying on expert. Because one portion I think that it seems that epidemic one part is correct.
Yes.
I am reading from the expert.
Yes, it says B and D both are correct, but in the chart you have mentioned that it is incorrect. B was correct and D was wrong. It was incorrectly said. So it is
Could have go by that.
B and D both are correct. And petitioner suggests that the 1 minute. The challenge of the petitioner was that the question is wrong or out of syllabus. It is not correct or incorrect.
No.
Question is wrong. Which one? Question number 5.
No. Serial number 1. First one. Question 2. Chart.
Question number 1 chart.
Just now that you read.
Serial number 1.
Serial number 1.
Question number 2.
Question number 2. Objection is of the petitioner is that the question is wrong or out of syllabus.
The wrong type. The exact would be that expert's report. Which
No, expert report I'll see, but the objection of the petitioner was that it is either a wrong question or out of syllabus question. There is
not correct. What he is saying, that's not correct. Our answer is both the question B and D are correct. It is not a wrong question.
And not out of syllabus. All right. And question 7.
Question number 7.
Question
number 7. Question number. Petitioner suggested the question is wrong or out of the syllabus. Every answer is suggested options A to be correct. Expert concerned with the preliminary answer. Concurred with the preliminary answer. Either the question is wrong or out of the syllabus, that's also not correct.
Not correct.
We have dealt with it in paragraph 7.
And these are the 2 questions. So you are out.
But what my lord has fallen for my lord senior with respect to 1, my lord, the recording of them that I suggested the question was wrong or out of syllabus. That is one of the objections. Another was the same which my lord senior friend said, that more than one answers was right.
No, they say that it is only B and D both are correct. B and D.
So in that event, my lord, my complaint was right.
Which in which one did you put a tick? B or D?
That I'll have to see, my lord.
Then
But
He is
B,
complaining
no,
that is the
no. What I'm saying, my lord, I'm saying this. that
Alright, if
more
you have
than-
not ticked B or D, then
Yes.
you do not get marks.
My lord, D possibly, my lord, that I'll just apprise to your lordship. D possibly I ticked,
possibly not.
but I'll just apprise to your
Stick
lordship.
up,
that. I'll do
because
that. I'll do
there was chance
Yes,
given
yes.
to you for filing an exception.
Yes.
You did not. And the next one also, it is the same thing.
But
It
next
is-
one, my lord, is completely, it is completely on the face. They suggested I suggested the question was wrong or out of the syllabus. The answer, it was never, my lord, scanned through that, my lord, query. It was said that whether the answer is right or wrong. So I never said
It
that
is-
the answer was wrong.
No, they say that the question was proper.
No, that is their contention. Lordship will see.
Question
This
is
is evident.
proper.
Question, Lordship will kindly see is it is evident from their answer. They never scanned through that, my lord, scope, which I said that it is out of the syllabus. They said that the answer is right.
No, they also say that it is within the syllabus. This
But
is what
that-
the
your lordship will see where I did not find this, because in the-
paragraph 7, it is said somewhere.
The moment I am saying this question is correct, how will come?
question must be correct. Why the question will be wrong?
Please. Allow
Because
me.
I said, my lord, it was out of the syllabus.
Petitioner accepted. Furthermore, the objection question number changed, but while petitioner says all options are correct. Where have you mentioned in the report that yes, it is within the syllabus? Have you mentioned
Because
anywhere?
if the questions are correct, that means it is within the syllabus.
No.
B and D are correct.
How can that be?
B and D are
The-
correct.
see, somebody appearing in class 2, given a question of class 4, the question is correct, the answer is correct. But for class 2, it is out of syllabus. It
And
is.
see, whatever is out of syllabus,
Ah.
we have given that note in the expert report also.
Where is that?
Can you see that?
Where is that? In the expert report, there is not a single mention about out of syllabus.
Kindly come to the expert report question number 5. Second one. Question is wrong.
Question is wrong is wrong.
Wrong means we have expert has said the question is wrong.
That is wrong. That doesn't mean it is, even in syllabus, it can be a wrong question.
Yes, in syllabus, but when grading itself, A and D, that means it is within the syllabus.
No.
No, ma'am. Not
You think it. Yes.
Just a minute. Give me 1 minute. Kindly come to Miller.
You are part of the report.
Page.
Second line. An email.
Email.
And this is to solicit your kind assistance as required for reviewing the preliminary model answer key of the recently concluded 22nd SLT 2025, which is planned in West Bengal for class 9 and 12, home management and home nursing. We uploaded the preliminary keys as suggested by paper setters moderators after the examination. And this review exercise has been carried out in terms of the grievance are basically of whether though all of them may not be relevant for your subject. Grievance that the choice in the preliminary key is wrong. Option B instead of option C in the opinion of the candidate. Most grievance that the more than one choice in the preliminary key are correct. Grievance that none of the choice in the preliminary key is correct. Grievance that the question itself is wrong. Grievance that the question is out of syllabus. And grievance that the English version and the Bengali version can reflect a different meaning. On this, the report has been given. They will short for whether it's out of syllabus or not. Then similar, expert 2 has come.
Yes.
No, that is a general mail. That is a completely general mail, my lord.
What do you mean by general mail? This is being mailed to the expert and you say it's
Absolutely.
general?
But lordship sees it is completely a general allegations. It is not with respect to specific question. If that would not have been the case, then I would not. My lord, kindly appreciate, my lord, here.
Petitioner heard the submissions made on behalf of both the parties. Stop. the issue relates to grant of marks on, not grant, awarding of marks on account of the discrepancies pointed out by the candidate within the stipulated time period in the second SLST, 2025. Stop. It appears that the objections raised by the petitioner was duly considered and the same were not accepted by the expert committee. Stop. Paragraph. The petitioner is aggrieved. Stop. The court is of the opinion that since the experts have formed an opinion and have considered the objections raised by the petitioner, accordingly, there is no further scope for the court to reassess the questions or the answers in the said examination. Stop. In view of the above, the writ petition fails and is hereby dismissed.
As your lordship.
29. Exception? Copy served? No?
No, perhaps copy has not been served.
Why?
Malad,
What is the grievance?
Yeah, you are asking him, Malad, why copy has not been served, Malad.
This is also the expert committee.
Yes,
What is
Malad,
the
still
objection?
in respect of only one question.
Objection.
Yes. My objection.
Correct answer will be option C and not B. And according to the expert.
But subsequently it is found that both answers are correct.
So did you get marks?
Yes, the expert never says that my answer is not correct. Expert only says their answer is correct.
Sorry.
But the expert.
The petitioner is
aggrieved. I have annexed the supporting documents.
In which
the answer they have not considered.
Dealt with the objection raised, objection filed by the petitioner in the second SLST, 2025. Stuff. Submission is that the expert did not consider the study materials provided by the petitioner in support of the submission that the answer made by the petitioner is correct. Paragraph.
They
I have
never said
heard
my answer is incorrect.
The submission made on behalf of the parties. Stop. And not stop. And peruse the report filed by the commission. Stop. It appears that the petitioner objected to question number 4 of series D. The objection was that the correct answer will be option C and not B. Stop. The preliminary answer key recorded that answer B will be correct, but the expert, and the expert concurred with the preliminary answer key. Stop. The court, not being an expert over the subject, will not like to reassess the question or the objection raised by the candidate.
Shortfall of only 1 mark. My answer is also correct.
According
but
to
if they consider the both answer is correct, then kindly consider this aspect only.
There may be several candidates with 1 mark shortfall. The court is here.
They never said that my answer is incorrect.
They say A is right, which goes to show that B is incorrect.
No, Malad, in several, but in another question, they have said both answers is correct, Malad.
That means both is correct.
If both is correct, Malad, both will go to marks, Malad.
You do not fall in that category. Yes. Next. This is also the answer script.
Yes, my lord, I would like to file the exception. I'll file the exception. Give me 7 days time, I'll file the exception.
On the prayer of the learned advocate for the petitioner,
it's ready.
To file exception to the report filed by the commission, hearing of the writ petition stands adjourned till 2nd February 2026.
27th, your lordship kept similar matters.
27th, already 27th.
27th.
January. Yes, 31.
27 January.
But 31 minute I am for the
31.
But 31 minute I am for the petitioner, my lord. But the petitioner is agreed by the wrong answer key in respect of only one question, my lord. Petitioner all were successful and were called for the next round of the selection process, my lord. But I am using my the exception to the report filed by the
Yes, yes. What is the objection?
my lord, in respect of one
Option D.
option according to my lord, the model answer, my lord, option D was the correct answer, my lord.
Yes.
And I have but in the final answer key, my lord, they have stated, my lord, they were B and C were treated as the correct answer, my lord. Since according to petitioners also, my lord, the option D was correct answer, my lord. I had no opportunity, not required for raising any objection, my lord. According to model answer, my lord, also, my lord, the option D was found to be as a correct.
Please come. The petitioner raises. The petitioner is aggrieved by the manner in which petitioners by which their answers were evaluated by the expert committee in SLST 2025. Stop. According to the petitioner, option D was correct. Stop. The experts opined that option B and C were correct. Stop. The petitioner submits that as the as a preliminary answer key found the answer given by the petitioners to be correct. Accordingly, they should be awarded marks for the same. Stop. Paragraph. As it appears that there were several objections. There were as many as 98 objections raised to the answer found to be correct at the preliminary answer key stage. The said question was forwarded to the expert for their opinion. Experts. The experts opined that answer B and C are correct. Stop. The court, not being an expert, would not like to comment on the answer provided by the experts committee. Stop. Next. The court is unable to provide any relief to the petitioner as claimed. The writ petition fails and is hereby dismissed. Next.
Next is also, my lord, exception is to be given.
Very well, exception to be given.
27.
27. 32 is same as 30.
Number 33, my lord. I appear for the petitioner.
And in 33, my lords, I appear for the CAN petitioners. My lords, this pertains to panel and out of panel, which all my lady is hearing on the 13th.
28.
30 and 32 items. 30 and 32, 28.
Yes, please.
28.
My lord, this is a matter where, my lord, on
33.
there was a direction.
This is out of panel and panel, my lady.
All right.
This is a matter, my lord, where I have prayed.
All right.
My lord, in this
panel. These are untainted candidates, my lady.
tainted matter, it was today, your lordship may take it up on 13th. I to suppose that there was a direction for affidavit, my lord. Let them that has not been given by the commission.
Let that be given.
Let that be given
We
today.
have filed an application in.
Lord, I have some objection on addition of party.
That these panel issues be heard on the 13th. There are already 4 petitions listed on the 13th.
That lordship will hear everyone. So,
The respondents were directed to file opposition. You have not filed?
No.
In all matters, you all file it. Is it ready?
This matter, they are taking time. No, my lord,
Now that we have filed the can, subject to lordship can consider.
I have also filed a
We may
can.
be added as parties and we
Yes.
may be given a very short opportunity.
But that is there in paragraph 23 also.
We may file,
Kindly
and the
look at-
13th, your lordship will be hearing another set of matters involving, I am told, that
Yes,
involving identical questions. Those matters will be tagged together and third set of. That is my respect.
My lord, in item in 13, the matter which has been fixed, affidavits have been given, we have also filed our reply. The matter, that matter is ready.
Addition of party may be allowed.
Copy not
By
served.
your order dated 10th December, you had said that the
Arre,
affidavit
scatter
in
na
opposition
Ajay
will be
Malad,
filed
this is the
on
matter
23rd.
where
This is the out of after
yes,
Out
yes,
of panel.
after expiry is under
Yes.
challenge, and petitioners are praying for publication of a list of first and second phase of counseling other than everything. These are the two specific prayers, and their candidature may be cancelled because several. And my lord, I am a successful candidate.
And was this matter taken up to the Supreme Court?
No. This matter was
No,
not
no.
taken up to Supreme Court.
Your
No one has
ladyship is
challenged this
hearing
matter.
all of these on the 13th. Your ladyship is hearing all these matters on the 13th. There are 4 other petitions listed therein.
Allows the can, subject to lordship
no,
consideration.
that is being allowed in all the
You
matters.
all are opposing or lie on the same footing as that of the petitioner?
Opposing.
Opposing.
But we would be affected because our appointments are, my lord, after third counseling.
Representing the third counseling can.
Yes.
We are phases
Well,
4
according
to
to me,
7.
up to
The
second counseling
appointments
is
are
better.
phases 4 to 7.
According to me.
You may be.
Counseling phases 4 to 7. Rounds 4 to 7.
Yes.
Third council within the valid.
We may be given
My lord.
opportunity to file affidavit.
Yes.
My lord, my prayer is
How many
this.
applications are there?
I have can 1.
Seven.
My lord, all
I
copies
am
have
can
not been
7.
received.
1 to 7, our 5.
1 to 7.
Mine.
7 applications you have filed.
No. Our is our 5.
My lord,
Rounds 1 to
All
7,
five.
my lady. In panel is 1 and 2 and
one.
3.
One.
4 to 7 is out of panel.
My application is
There are 7 applications in the list. Allow each of them.
My lord, kindly record that I oppose it. My lord, kindly record on my.
Acha,
copy shop point.
Well, and all copies are not being.
copies will be directed to be served. Acha, लिखूं ना अपनी 7 connected applications have been filed in the instant writ petition seeking addition of party. Stop. Learned advocate representing the writ petitioner opposes the addition. Stop. Paragraph. As it appears that any order passed in the instant writ petition may have rippling effect on the others. Accordingly, the court thinks it fit to allow all the applicants to be added as parties in the instant writ petition. Stop. The department is directed to make the necessary addition at the earliest. Stop. The application for addition of party shall be forthwith served upon the learned advocate representing the writ petitioner.
If not served.
It's been served. Yes.
If not served earlier. ঠিক আছে next হচ্ছে the respondents and the added parties will be at liberty to file affidavit in opposition by 6th February 2026. Reply if any by 12th, list on 13th. The other matter is on 13th?
13th January, my lord, January.
13 January, my lady. 13
30th?
January. The other matter.
13 January.
13, 1-3. 1-3.
My lord, kindly tag this.
1-3 January is
Should be served upon us.
Only the cause title.
Cause title means we do not know the cause title.
Cause title, amended cause title.
Cause title.
Cause title.
Your lordship is keeping it on 13th February, but other matters are coming up on 13th.
Other matters are 13 January.
Whatever will happen, will happen. I do not think it will be finished in a day.
And
It
that's
is
the
going to
reason.
take time with so many parties over here.
And then, my lord, I
I am fixing up matters on staggered basis so that these matters and other matters are also taken up. Otherwise, the second SLST matter is going to consume the entire court's time and other matters cannot be taken up. Right?
my lord, the fact.
No, 13th.
Your lordship will be taking up the other matters on 13 January. My lordship, we will remind your lordship that these matters may be posted.
Let it remain. You all also
One thing,
say your
13 the
file
affidavits have completed.
Listen, very well. Then the stand of the commission is there.
Yes, my lord.
The stand of the commission, the court, I have mentioned that the court will not shut out anybody.
Yes, yes.
I will hear everybody. Let everybody's submission be recorded.
All should be heard on a day, my lord, when your lordship fix the matter.
No, this cannot be done. Otherwise, this is going to continue.
My lord,
The understanding is at the end, as
Yeah, that was Tito very big.
No.
Very well, because you all will be supporting these candidates.
That's the
yes.
I can understand.
and I have to make, do not kindly excuse me, I have to make my time. That's the reason.
Yes, you make your time. এটা কি 34? 34? 34?
My lord, the amendment,
My lord, only one thing, the amendment may be done by the department.
Yes. Amendment, it has been mentioned. Department will do it.
my lord, and the affidavit they have not,
This is
affidavit the commission has not given in this matter. Let them serve the affidavit.
They have not prepared. They will prepare it and serve.
ঠিক আছে।
They have not prepared it.
We are prepared.
Yes, 34. 34.
Grateful, my lady. Grateful.
On 12th December, my lord passed the order in this matter.
Yes.
My lord,
Petitioners have been found to be disqualified on ground of overage.
my lord, kindly see para 14 onwards on 12th December order.
Yes.
Para 14 onwards, my lord. Reliance has also been placed on a judgment delivered on such and such. Para 15. The Supreme Court in
Yes.
aforesaid matter observed that it is desirable that the state selection board and the bodies conducting the public
Has any
selection-
opposition been filed?
7 days. Give me 7 days.
Acha, on the prayer,
Interjected with the other matter.
on the prayer of the learned advocate representing the commission, time to file the affidavit stands extended till how soon? How soon? All right. Tahale for the respondents korun, not only the commission.
Give me 2 weeks, my lord. Give me 2 weeks time.
All right, 30th of January, 30.
My lord, but
If any, within a week thereafter. List on 17th of February 2026.
my lord, another important aspect in this matter is that, my lord, in camera proceedings, my lord, my lord's order on 15,
Yes, in camera
para
proceeding.
15, my lord.
Yes.
15,
Yes, I have seen that.
ঠিক আছে। Interview process, my lord.
কবে?
My lord, this is, my lord,
নেই নতুন করে
Of
একবার is in-
use of camera, because I tell you, lordship, here camera, etc. In outside to the press, everything is disclosed. And unfortunately, my lord, your lordship will.
Why will you bother what is being said outside?
Sometimes it is difficult for us. My lord, only I.
The Supreme Court has opined
Yes,
that it
you
should
find
be in
yes.
camera.
Yes.
It isn't
Supreme Court
3rd
judgment
December
is-
2025. The judgment, it has been mentioned that it should be in camera. It is recorded in the order.
Although it is a desirable. Yes, this order has been kept in evidence.
No.
Order.
Yes, this order. Supreme
Show the
Court.
order.
No. Just a 1 minute. What I will show out, what I will not show, that you.
Obviously,
you
because
don't dictate.
because of that, my lord, if the Supreme Court order, I am submitting before the I am before the court, my lord. In each and every matter, my lord, if you are a senior advocate, that's why you show the red eyes. It is not work. It is not every time. It is not work.
Please, slow. Everybody is hungry.
2 hours I argued a matter. Court
All
has
right.
said, I am with you, Mr. Bandobad.
Yes, it's
Our
all right.
interest is to consider.
Yes.
I kept the judges' desire. I kept the judges. I mean, this is a respect to the judges.
Yes.
What is going on saying outside?
See,
One must be
what
fair and normal.
what he says outside is not a matter to be taken inside.
Supreme Court যেটা হয়েছে, these types of order, one was challenged and it has been directed to be kept in evidence.
Which one? State of Meghalaya? Ajay Hasia, which one?
No. Your lordship's order are
No, the Supreme Court's order.
Supreme Court's order are not. I am not about Supreme Court's order.
This is what is recorded in the see the last order of the court. You are mixing up matters. There are so many you are mixed up. Acha, whatever is there, please see and follow it. ওই মামলাগুলোকে ডাকুন তো।
No, against this order we have filed the SFP. Similar
and it's pending.
pending and similar order has been passed.
I do not know. Where is the similar order? Please show in this matter.
No, no.
Nupur Ghoshal. Nupur Ghoshal.
I will show you.
You are mixing up things.
Mixing up.
Nupur
Yes.
Ghoshal affidavit, the SLP file.
Yes.
Order.
Shall be filed, but not yet.
Not order passed. No order passed.
No, no, SLP filed. It is under
Consideration.
verification.
All right. Go. Yes. Call. Old matters.
SLP number.
Yes, yes. Now you go for your recess.
SLP number 638 of.
All right, go. Din.
638 of 2026.
All right. You all go. Finish. Finish.
Pilot will not sit after.
No bench.
I am thinking so. This is the reason I am continuing. Old matters. Follow the list. Follow the court. কত নম্বর আইটেম আজকের লিস্টের 162 of daily list. Is anybody there? Dismiss for default. 163 dismissed. 64 all dismissed. 165 dismissed. 166 daily list
167
dismissed.
168
Dismissed.
169
Dismissed.
170
Dismissed.
71
Dismissed.
172
এই লিখে দেবেন nobody appear. Yes, dismissed.
174
Dismissed.
175
Dismissed.
176
Dismissed.
177
Dismissed.
180
Dismissed.
181
Hello, 181 to 188, my application, already my purpose already been served. My purpose already been served after filing this writ petition.
All right.
181 to 188.
181 to 188. Record an order. 77 reports 178. 178. Nobody is there. Dismissed. 179 dismissed. 180 also dismissed. 181 record an order. Learned advocate for the petitioner submits that the grievance of the petitioner stood redressed after filing of the writ petition. Stop. In view of such submission, there is no requirement of proceeding with the writ petition any further. Stop. The same stands dismissed as infructuous. 189 dismissed. 190
190 is a primary matter, SSK matter, madam.
SSK matter released from the list for want of determination.
Since it has monthly list, I don't know, 936. Lordship, in matter of personal order, I will run from that building.
Yes.
My name is not Sir Miller.
আচ্ছা ওনার নামটা নিয়ে নিন তো একটুখানি
My lord,
order was passed
matter dismissed.
dismissed for default.
Petitioner was not.
196 of the monthly list
936.
একটু দিয়ে দেবেন ওনাকে স্লিপটা
My lord,
All right.
that is fallen for your lordship, that his lordship is not going to sit item number 55. It is pertaining to second SLST, my lord. There's certain urgency. Some precedence may be given on the next date. my lord.
there are many SLST matters
এই ওরা তো ওরা তো ওর হয়ে জেল খাটছে তা ওদের এত ঘটনার পর কিন্তু ওই করছে ওরকম মন্দিরে এই স্তর নষ্ট করছে কিন্তু বটে লিজ তো এত ঘটনার পর লিজ তৈরি করছে মাস্টার তবে রেড কমিয়ে দিন রেড কমিয়ে মানে রেড কমিয়ে বেশি কোয়ান্টিটি বাকি আমরা এটা লাগছে না বলে তো তুই না না ওই আর কি